Appeal is dismissed.
May I please have Lordship, my lord? Today list, my lord, item 5.
Yes.
I have filed bail application with same FIR, my lord. So, my lord, today listed as unlisted, my lord.
No, I don't follow you. What do you say?
One,
Item number 5.
yes, my lord.
Yes, what do you want?
FIR, my lord. Yesterday I have filed, my lord, bail application.
Acha.
Today, my lord, as unlisted, my lord. Maybe allow, my lord. Fine.
All right.
Fine.
This is the same matter.
May I please, your lordship, I beg to mention item number 24, 25 of the daily list and 66 of supplementary.
One by one. 20,
24, 25
24, 25. Yes.
and 66 of the supplementary list. Actually, all these matters are connected matters, lordship, arising out of the same FIR. Lordship, I humbly pray, lordship, this matter may be again taken up on Monday, lordship, on 10th of November, lordship.
On the prayer of
BP may-
counsel for the petitioner, is the matter again on 10th.
Deeply obliged, lordship.
Yes.
With regard to item number 51, may I make a prayer for an upgradation of the matter, madam? Maybe can it be taken up at 2, madam? Why I'm making it in such a prayer, madam? The next date of appearance is on 13th. Then the records are here, madam. Records. Records are here. Can the matter be taken up at 2, madam?
What if it comes up before that? Huh? Should we wait for you till 2?
Then, chairman.
Yes.
May I reply between item 48, Lordship?
Hmm.
In this matter, service is awaited, Lordship.
Okay. 48.
As per office not dated 4/11/25.
Await service on respondent number 2.
2, Lordship.
Yes. List again on when?
After 3 weeks.
All right, after 3 weeks.
Lord.
I think none of them.
Okay.
May please, your lordship.
Item
If you will
one,
find
Lordship.
the FIR at page 13.
Lordship, here, item 1, yesterday we have received. Let the matter be come up before this honorable court after the motion matter.
This
It is
item
a-
1.
Yes, it is available.
Okay.
Lordship, by
That means timing.
Yes.
May I please, Lordship? Lordship, matter may pass over for timing, my lord.
What is there? This
In the earlier occasion, CD was called for that we have not received. Lordship, may kindly give us a date. It has perhaps strongly come in the motion.
okay, if CD is not here. What is the point of timing? List again on CD not received. List again on.
Lordship, can it be on 14th?
All right.
may please, your lordship. Lordship will find the FIR at page 11. And after 13 years of marriage, he has lost this FIR. He woke up, suddenly she woke up from slumber and lost this FIR also on 14/10/2025. Lordship will find the FIR, translated copy of the FIR at page 11.
Sir, seated, no matter. Sir, seated.
Here it, lordship.
Yes, this.
Lordship, yes, tell.
What date will be given?
Lordship on 70.
Item 4.
Right, please, Your Lordship. Your Lordship will find page 9. As on today, 72 days in custody, Lordship. After 17 years of marriage, Lordship, that wife committed suicide. Suspecting that the petitioner is having some affair with some other girl. And forwarding report grounds of arrest, Your Lordship will get at page 17.
The allegation is a murder, isn't it?
Yes.
Allegation is a murder, but that Your
Then?
Lordship will find in the grounds of arrest, grounds it is allegedly stated that there is a suicide note also alleging that the girl has suspected the petitioner is having some affair with the girl.
This is registered under which section?
103.
Then,
Murder.
But in the grounds of arrest, that
It
that
be along with the
Sorry.
postmortem report also.
CD.
short date may be given, Lordship, because already 72 days.
CD with PM report.
Yes,
Okay.
Lordship.
Give a short date.
On 17.
Problem.
My Lordship. For 82 bail application, Lordship, FIR is on page 3, motion matter, type copy, Lordship. What effect? May I read the details, I'm reading out the details of the incident. I was waiting for my ride near Hotel Tridep, below Bhangagar, when one person came and started talking to me. Subsequently, two persons came and introduced themselves as policemen without inform and started questioning me for talking to the first person. They asked me to come to the police station, and in the meantime, they opened the hook of my gold chain that I was wearing and.
When were you arrested?
Lordship.
Date of arrest?
Database is Lordship,
Date of forwarding is 20.
19/9/2025.
Date of forwarding 20.
19. But it is 50 days today. Lordship.
50.
uh,
50.
50 days.
It's from Kamrup Metro, Lordship.
Lordship, I am. Lordship, see that,
On
Page-
13, Lordship.
Lordship, page 16, Lordship, page 16 is a forwarding report. Can you page the page 16, Lordship? The operation person is Lordship, page 17. Is a ground of arrest, Lordship, para 4. That's where that is I am. That's where Sunil Mandal received the snatches ornaments from the accused persons without any proper papers. This
What
is the
was
allegation.
recovered from you?
No, nothing has been recovered, Lordship. Even Lordship, in the FIR, the details of the same is not mentioned. The weight, prices, nothing, Lordship. The main accused is, they have shown that one Abul Kalam Azad is a habitual offender, that it is shown in a count of arrest.
They even found a jeweler who received a stolen item.
Yes, Lordship.
No.
That is mentioned in for grounds for arrest,
Yeah.
number 4.
Lordship,
Yes.
as per FIR, Lordship, as per.
Forget about FIR in ground. You are pointing to the forwarding report. That is what we are reading.
Yes, Lordship. The jeweler Sunil received the snatches ornaments from the accused person without any proper papers. It is an allegation from the police person, because nothing has been.
You are relying on the forwarding memo, and then you, when it goes against you, you say it's the police.
That's by submission.
person.
By submission.
Yes, your submission is contradictory.
They say only by
Blowing hot and cold at the same time. Okay, Kamrup Metro,
Yes, Lordship. On 13.
Tuesday.
50
13.
days. It is 50 days, Lordship.
12, Lordship.
Tuesday will have.
Yes. 12.
Mobilize.
Okay.
May I please tell Lordship? In this case, my lord, earlier we are on bail, my lord. Subsequently, my lord, on non-appearance of some dates, NBW was issued. For which, my lord, I approached before the trial court that I did not got relief. Subsequently, my lord, we filed a criminal petition before this honorable court. However, the case was listed on 23/9, my lord. On that date, my lord, due to the demise of legendary icon Juven Crux, the close suspicious seat was closed. Subsequently, it was listed on 25/9. However, on the last night, my lord, we were arrested. And my lord, kindly see, this is it. Only because of that, on 45 days, we are in custody. On the pending of anticipatory bail.
The matter is solicited.
Charge sheet my lord, long back, it is a charge sheet dated page 22 is the charge sheet.
That is what happens when you don't appear.
I will appear my, will appear my. Because the other two persons were also arrested, they were subsequently released on bail. Total 4 accused
Before solicitor.
after charge. Trial was going on, my lord. Will appear, my lord, very silly offense, my lord.
Originally you appeared.
Yes, my lord.
Charge was framed against you.
Yes, my lord.
Okay, heard learned counsel for the petitioner, also heard learned additional PP. This application has been preferred, seeking bail for the petitioner who was arrested on the basis of an NBWA issued by the learned trial court due to his absence at the time of the trial. It is submitted that after charge was framed against the petitioner under section
Under section, my lord, this is
379.
376, my.
379.
379, 376. 376 is there.
376 and 379 both.
No.
Huh?
Yep.
What kind of a person are you?
376, my lord. A charge was framed.
The 376, he,
Receipt submitted under 294, 376, 506 and 30.
okay. He had initially appeared, and how many witnesses were examined?
No witnesses.
No, initially he had appeared, but on subsequent dates. For what reason were you? have
My
you
lord,
given?
actually, we are very actually daily wage laborer. However, my lord, the advocate did not inform us.
And that he could not appear due to lack of information from the engaged counsel. Because of which NBWA was issued against him. The host of the petitioner had sought relief before the learned trial court, and thereafter before this court by way of a criminal revision petition, but before the same could be disposed of, he was arrested on the strength of the NBWA issued by the learned trial court. Thereafter, the petitioner has spent 45 days behind bar. It is further submitted that henceforth the petitioner shall regularly participate in the trial and prays for enlarging him on bail. Having regard to the facts and circumstances, the prayer for bail is allowed. Shall be released on bail of rupees 50,000 with 2 sureties of like amount to the
Lady wage laborer.
to the satisfaction of the learned trial court. It is further provided that the petitioner shall regularly appear at the trial. Bail petition stands disposed of accordingly.
God bless.
Made with this one. So as this matter, the petitioner has already been behind the bar for 44 days and find the affair in page number 14, my lordship. May I read?
And he has not been recovered, it seems.
But so far the
5 lakhs.
Yes.
but here as the allegations and nothing has been recovered from the accused person and so far the arrested.
Okay, we'll have the
person-
CD.
Yes.
Date.
Lordship, on 18, Lordship. 18.
May I please tell us? My lord, today is 60 days in custody.
What
And
is the
my lord,
offense?
The offense is committed by my son, my lord.
Huh?
offense, whatever offense is, my lord, labeled in the
Why do you
FIR.
say whatever offense? What is the offense?
Offense, my
That
lord,
is the
there
question.
is a attack by the sharp weapon. This is a dao, which was also revealed there is a blast stain which is recovered. It is recovered from my house. However, the offense committed by my son, my lord. So after committing offense, son, my lord, took shelter at my house. I, being the father, was at market, my lord. Subsequently, I, my lord, reached home on getting this information. And now, my lord, on getting home, my lord, I was kicked up, my lord, by the police. I'm Kumaresh Das Chaudhary. I'm the father, my lord. And my lord, 48 notices I have annexed,
Is
which
the
is
FIR named accused person?
page
Is
13 and
the FIR
14.
named accused person?
Kindly see the 48 notice.
Accused
Where
number,
is the FIR?
FIR, my lord, is page 11.
page 11.
11.
What is your name?
Mine is Kumaresh Das
Kumaresh.
Chaudhary.
Accused number 2.
Yes.
The Shanu Das Chaudhary is my son, my lord. And this is the 15 years boy, my lord.
Allegation of serious physical assault.
No, you were a participant in the assault.
It is
Why
in
do you
the
talk,
FIR.
keep talking about your son?
It is in the FIR, my lord. How, my lord, I become a father, my lord, participate, and victim is also a 15 years old boy, my lord. He is the friend of my son, my lord.
How you can participate? That is
These are
for
the,
you
my
to
lord,
say. But
four boys, my lord, have, my lord, was gossiping under a banyan tree, my lord. So some altercation was took place, my lord. And my lord, my name is entered in the FIR itself. However, my lord, recovery was made from my house. So my submission, my lord, 48 notice I have also annexed, my lord, which is not my lord, as per,
statutory period is what?
I'm sorry,
Statutory period is 90
90
days.
days.
90 days.
Then
no.
90 days.
why do you keep harping on 60 days then?
Yes.
60 days, my lord.
Okay, CD.
My lord, kindly see page
CD
13,
along with injury report.
Okay.
page 13 and 14, kindly see.
Yes, what is there in 13
It
and
is
14?
48 notice, my lord. No signature is there. No signature of the arrestee, no signature of the informed person, no signature of the,
I don't know, there may be a arrest memo. Have you annexed?
no, my lord, arrest
is
is
not
I have
there.
not found. This is a 48 notice.
That is also good enough.
A short date may be
Yes.
given.
From Sri Bhumi Road. On 18.
My lord, short date, my lord. My lord is an old man, 60 years old man. In this case, my lord, we are the, in fact, we are the victim, my lord. And we have been victimized by the police itself. We have not committed any offense, my lord. What we have done, my lord, we have not done anything. It is itself reflected in the FIR itself. My lord, for a moment, kindly see para 3, my lord. Para 3, para 4, and para 5. What is the real incident which I have annexed?
To the FIR first.
I think there was one similar matter.
A similar matter, page 60 and 61.
60
And 61.
page.
No, my lord, item 60 and 61, both are similar.
No, the any application had come earlier in respect of this
No,
FIR.
my lord, I have not filed anyone. My lord, kindly see for a moment, page para 3, my lord, para 3 and 4.
Come to me. Why together?
My lord, kindly see the FIR. Para 12.
You are
I am Samsul Haq.
Samsul Haq and Tafajul Ali.
My lord, kindly see para FIR itself.
you are at serial number what in the FIR?
In FIR, my lord, I am serial number is, my name is not in the accused name here. Not in the accused name. However, in the contention of the FIR, my lord, may I read, my lord, for a moment, please?
No, in the contents, no name has been given.
Yes, my lord, my name is given in the FIR. May I read, my lord, para 12, second para.
Para 12 or page 12.
Page 12,
12,
I'm sorry,
okay.
page 12, second para, my lord.
Samirul Haq.
Samsul Haq, because Sarimul Haq, my lord, is wrongly. Sarimul Haq is the Islamic scholar. Samsul Haq, page 13, first line.
Samsul Haq.
Yes. Samsul Haq Katdehar on the instruction of the informant. Informant is the father of the victim's son. And why my lord, the Samsulok brother instructed because of the decision of the village
So
trial.
how many days in custody now?
My lord, today is 48 days.
Heard learned counsel for the petitioner. Heard learned additional PP. This is an application under so and so. As per allegations contained in the FIR, the son of the informant had used abusive language against an Islamic scholar, and despite tendering of apology, the accused persons compelled the present accused, Samsul Haq. Present accused is
Yes, Samsulok and Tafazul Ali. And Tafazul Ali was also my relative. He was the spectator of that village trial. Nothing else.
And Samsul Haq's name is there in the FIR lordship. Your
Mhm.
lordship will get it at
Samsul
particular
Haq to
page
cut
40.
the hair and necklace of the informant's son. And he was also humiliated by hanging a necklace of shoes upon him, and also threatened him by showing a dao.
State court here. Oh, I have luck. Published.
Where the petitioner was arrested on what date?
Arrested, my lord, on 22/9/2025.
And therefore he has already spent how many days?
48 days.
48 days in custody. And the investigation of the case is also expected to have progressed. Full stop. Having regard to the above, prayer for bail is allowed. 20,000, one surety. The conditions, you can cooperate with the investigation.
You are
61, my lord, same offense, my lord.
But who, Asaid Ali is whomever named accused.
No, my lord. Shahid Ali.
Okay, same order, we'll make the corrections later.
However, my lord, I was arrested in 39, Shahid Ali.
39. Date of arrest is 309. So number of days?
So number of days are 40 days.
40.
40.
40.
Obliged, please.
Report was called for regarding the registration of an FIR against a petitioner. So that report is not, that is awaited lordship. We have not received.
The report as called for has not been received. This is the second occasion, I think.
Yes, lordship.
Which police station?
It from Sorbuk lordship, Borpeta.
OC Sorbuk PS is directed to furnish the report without fail by the next date fixed.
On 19.
Communicate the order accordingly. Please the matter again on
19.
7.
again. Report
Reporter.
Lordship.
received.
Not received lordship.
Same order. Which PS?
It's from Nagaon.
Okay. Instead of Sorbuk, write Nagaon. OCPS. PS.
Wait, as per your lordship direction, with the 13/10/25, my lord, the petitioners have appeared before the honorable, appeared before the IO, my lord, on 15/10, my lord.
City come.
It has strongly come perhaps in the motion column. So we do not have the case study right now. Lordship.
Okay, this case is wrongly listed in the motion column, and learned additional PP informs that CD has not been received. Hence, list the matter again on
20th of November.
Interim order, interim order, sir, continue.
interim order passed earlier to continue till the next date of listing.
Right. Yeah, please, your lord.
This is anticipatory play application, the FIR is at page 13. Here the lordship, the petitioners are not the FIR name accused persons. The father of the petitioner has been arrested in this connected matter, and police has been searching for them because they are a son of the Alaluddin. Your lordship will find at page number 19, where it has been mentioned in the forwarding the Alaluddin was being arrested. He is the father of the petitioners, and they are not, these petitioners are not involved in this case. They have been wrongly charged by the police. So they may be given opportunity to record their statement, your lordship, before the IO.
Where is the FIR?
FIR is a
Lordship, FIR is page 13 and it's a one.
What is your name?
Name 3 persons before Lordship.
They are Ikramul
Rafiqul Islam and
Rafiqul
Khadimul
Islam
Islam.
and Dimul Islam. They are the son of the Alaluddin, who is being arrested in this connected matter.
Same case.
Same case.
Hmm.
He is pending.
So there must have, your name must have surfaced during investigation.
Yes.
That is why they are calling you.
The things have already been seized. Your lordship will also find in the FIR, in the forwarding page 18. Everything has been seized. All the custodial interrogation.
Where?
At page 18 is at the lower portion has been mentioned that items has been seized.
All these items has been recovered from the possession of the arrested person. That is, his name is Laluddin, who happens to be the father of the present petitioner.
Yes.
Lordship, might be some nexus, so it is an anticipatory bill. Lordship may kindly cause for the case study.
FIR name and not also involved. Your Lordship.
All right, CD, you are not a stranger. You are the son of the arrested accused. So it's quite probable that CD will reveal your involvement.
Your
And
Lordship,
recovery does not, of certain goods have been made. It does not indicate that all the goods have been recovered.
On 17.
the matter has been fixed on 11, the other matter.
All right.
That will be fixed together.
Yes, Lordship. 11.
All right.
11.
11.
Other matters fixed on.
Chair,
I think this, your lordship has called for a CD, not inclined on the very first day because we have seen that there was some material in the case that it was rejected by the Learned Sessions Court. Initially, interim bail was granted. Thereafter, after going to the CD, some material, that's why your lordship was not inclined. So let the CD come, my lord, unless once your lordship has formed an open, I think.
All right, call for the CD.
Lordship, in the earlier occasion, also city was called for. Again, this matter has wrongly come in the motion coming.
Earlier order, actually, I think, I don't know. It says
No,
it's
yes,
the
yes.
matter again on 7/11/25.
So lordship has, it should come in the column of
Bail
bail
hearing
hearing.
wrongly come.
Matter has been wrongly listed in the motion column. CD not received. Issue reminder for the CD. List the matter again for bail hearing
On
on
1911.
19. Get the CD, okay?
Yes.
April.
Please, Your Lord. The anticipatory bail petition, my lord. FIR is at page number 14, my lord. Section 108 is incorporated, my lord. This victim is the wife of the present petitioner, my lord. And the petitioner is a government servant, my lord. He is working now in Vishwanath, and this victim is also working in the APDCL, and she is living in Guwahati, my lord. FIR is at page number 14, my lord. FIR was lost by the mother of the alleged victim, my lord.
Just read it.
Denied. On the third day of alleged occurrence, my lord, when my wife was found hanging, my lord, I was in Vishwanath in my work, my lord. And
City of the required.
my lord, in this space, my lord, I pray for an interim protection. I'm a government servant, my lord. And that apart, my lord,
What are you?
I am the wife of the victim, my lord. I am a government servant. I am been working as a data operator, my lord, in the office of the joint director. Health
Who
Services.
committed suicide?
Wife of the president,
Gangotri से क्या?
wife of the petitioner, my lord.
That is what you are saying. You are wife of the victim.
No, I'm sorry, my lord.
I heard
And the
learned
husband.
counsel for the petitioner. Additional PP. This is an application under so and so. Paragraph 3. Be brief facts of the case. Bail petition. Call for the CD.
Along with the postmortem.
It is stated in the FIR itself that the victim and the petitioner, though husband and wife, were not staying together. And it is further submitted that the petitioner is a government servant and his arrest would cause serious harm to his career and would also result in his suspension. Full stop. Having regard to the above, it is provided that in the interim, the petitioner in the event of his arrest shall be released on interim pre-arrest bail of rupees 20,000 with one surety with the satisfaction of the arresting authority in connection with the aforesaid case. List again on.
Lordship, my objection. My objection may be required.
So, learned additional PP. Heard learned counsel on the prayer for interim relief. Learned additional PP opposes the said prayer. Yes.
Hello.
On 24/11.
May I tell Lord? Lordship in the case, Lordship. As per the order dated 13/2025, Lordship, I'm to submit the salary slip, Lordship. And I have communicated to the petitioner, but due to last 3-4 months, Lordship, I could not connect him because he is posted at Kashmir, Lordship, Jammu and Kashmir border, Lordship. And because of the security purpose, Lordship, I cannot connect him, Lordship. I have contacted with his mother, Lordship. He
You are
started
working as
army, Lordship,
Huh?
an army personnel.
Army.
Army man.
Yes. What is the difficulty in submitting your salary detail?
No, Lordship, this I'm not even his mother also could not connect him, Lordship, because of the security purpose. There is not available mobile or any other document is not available. Lord. He will come, Lordship, next month, Lordship. In leave, Lordship. I can submit it, Lord. And regarding the order, Lordship, for monthly maintenance, his mother is the Lordship arranging to pay the monthly maintenance for the Learned Council who is appearing in lower court, Lordship. And there was also direction to communicate the respondent.
Yes. So what to do now, respondent?
Yes, Lord.
Lordship, in this
Yeah.
case, at the time of issuing notice, Lordship, they were directed to give 50, stay was granted only on the ground that 50% will be paid to the wife, Lordship, before the learned trial court. And thereafter, before the executing court, we prayed for the arrear amount also. The executing court restrained from passing any order as because there is a stay from this High Court, Lordship. So an order was passed on, Lordship. I have already submitted the certified copy. Maybe it is on the file, Lordship. The due to pendant, the relevant portion I am reading, Lordship. I have both the I have heard both the sides, learned amicus curiae, and also gone through the case record. Without repetition of the facts mentioned in my foregone paragraphs, it is observed that the Honorable High Court, by its order dated 2/12/2024, passed in connection with criminal petition number 1449 of 2024, state the order dated 17/11/2023, passed by this court in FC criminal number 42 2021 until further order. Where the Honorable High Court state the impugned order, it is by necessary implication that there cannot be any liability on the part of the second party to pay the arrear. However, as per the Honorable Guwahati High Court directed the second party to pay 50% of the maintenance allowance, the first party would be entitled to get a sum of rupees 10,000 per month from the second party with effect from the date of passing of the order dated 2/12/2024, and this court has no jurisdiction to give retrospective effect to the said order. With this observation, the petitions filed by the advocate for the second party and objection raised by the first party stand disposed of. So accordingly, the learned executing court lordship is not trying my petitions for arrear calculation. Then this court passed an order, lordship, that is on 13/5. That arrear may be calculated before the passing of the impugned order, lordship. But it may be recorded before passing of the stay order in this criminal petition. As it is reflected that before passing of the impugned order, then now again the court is saying that before impugned order, there is no maintenance order. So how can I calculate? Must you kindly go through the order dated 13/5/2025.
Lordship, is this 10,000, he is paying 50,000, 50.
You are paying.
Yes, Lordship, his father is.
In
regularly
10,000,
paying.
50% of the arrear amount, maintenance amount also, lordship, he is very irregular.
No, Lordship, that's not. May not be correct.
As
Lordship.
per
my.
order dated 13/5/2025, the arrear shall be calculated prior to passing of the impugned order. Now,
That may
That
be-
means from the date of institution of the case till the passing of the
Yes,
impugned
Lordship.
order.
Yes, Lordship, that may be, because there may be something, Lordship.
date
Yeah.
of passing of the date till the passing of the stay order,
No,
lordship.
That has not been stated.
But it stated that prior to passing of the impugned order.
Whatever, you are getting something.
Lordship, he is very irregular and I am
Lordship, I
there is no
produced
means to
the
survive
next
with
date,
my minor son, lordship.
So tell us when you can appear, when you can submit.
Next.
We'll finish off the matter.
Yes, Lordship,
Lordship.
and the.
Lordship can dispose of this matter, then the learned trial court will proceed for the collection of the
No,
arrear.
one-
No, there was a direction to submit his salary statement. For that, he is seeking time.
Yes.
So give us a firm date, on that we'll dispose of the
Lord.
petition itself.
Lordship.
And in this case,
Yes.
Lordship, the Neha.
No more adjournment will be taken, lordship.
Had learned counsel for the petitioner and
Lordship.
also heard learned counsel for the respondent. It is submitted that the petitioner, who is an armed force personnel, could not be contacted,
Yes,
and therefore his salary statement could not be submitted before this court pursuant to the earlier order passed by this court. Accordingly, prayer is made for further time to submit the said salary statement.
month of Lordship, December he will come.
Accordingly, list the matter again on, give the date of December date.
Second week, before vacation.
Just before vacation given.
Our, just because our.
15
vacation start from
December,
it.
lordship, if he can appear on
Yes,
15 December, lordship.
15 December.
Lordship. And there is a direction to provide the account number of the wife, lordship. I have just provided.
Yes.
He can, so that he can deposit the account itself, lordship. And no.
Just before that, you write, just before the last line, you write, the bank details of the respondent wife has been furnished to the petitioner. Yes.
And lordship, no more adjournment may be taken in
Yes,
this
yes.
matter. Endeavor should be made to dispose of this.
Who knows,
matter.
you may take adjournment.
Lordship always taking adjournment, lordship.
Okay.
Obliged.
Obliged.
Please, your lordship.
Yes.
The petitioner, my lord, is before your lordship, my lord, as against the 20%, my lord, of the check amount as interim compensation which has been, my lord, ordered by the trial magistrate, my lord. In this case, my lord, the accused petitioner, my lord, he has, right from the receiving the demand notice, my lord, he has denied that these checks are not mine, and he has also filed an FIR before the police station, my lord, that these checks are not mine, and I have not issued these checks. Subsequently, my lord, in this case, the trial has commenced, and the bank manager has also, my lord, appeared before the trial magistrate and confirmed that this accused person does not even have an account in our bank, and these checks are not his. The trial court records are also present before a lordship, my lord.
You are correspondent.
Correspondent to Lordship, my senior is out of station for medical treatment, Lordship. I could not place the adjournment slip yesterday, Lordship, because he's come on supply list, Lordship. I prayed for mentioning also, he didn't give any consent, Lordship. This matter may be passed over for the day, Lordship. Because I'm not
In the-
capable of.
No, there is no stay, my lord, as against the, my lord, order of the trial magistrate, my lord.
So when is your senior coming?
Lordship, next week, Lordship. Anyways, Lordship, the lower court next date is on 29/11. Any date
Let it
before
be fixed, my
29/11,
lord.
Lordship.
Yes, fix it on, list the matter on the prayer of learned counsel for the respondent, list the matter again on, give a date next week.
19. 14. 14 to 19.
What is the other case?
62, 63, my lord, same matter, my lord.
All right.
Much obliged, Lordship.
None appears. List again on so and so interim order passed earlier to continue. None appears for the petitioner. Scan, as per office note, scanned copy of TCR has been received. List the matter again on given date.
Wait, please, Lordship. Lord, 439, I was in jail, my lord, I was been granted interim bail because of non-compliance of 41A of CRPC, now it's 35P, my lords. So interim bail has been granted, my lord, and call for the diary, whether, my lord, any notice has been issued or not. For 3 times, my lord, I think, my lord, they didn't have produced the case diary. My lord.
We do not have the case study today itself, Lordship. We'll take care of it, Lordship. Give us a last chance.
CD not received. List again on so and so interim order passed earlier to continue till next date.
Let it be on 25, Lordship.
All right.
My lord, interim prayer was considered on 28th of September, my lord. by the-
Received.
CD not received,
CD not received.
Lordship,
List again on so and so interim order passed earlier to continue. Next.
on 24th. Lordship.
Published.
For this can be received, but the voluminous and I have to go through it also. So it's another thing to go through it. It's very voluminous.
When?
Next week, any day,
Scan copy of TCR has been received. Learned additional PP submits that the same is voluminous and some time is required to go through it. List the matter again on
17, Lordship.
any interim? No.
no.
16.
Yes, your lord. This person, my lord, accused the petitioner, he is behind bars since, my lord, 18/7/2025, my lord.
That is,
18 July, my lord, 2025.
I am asking for the number of days.
That is, my lord, more than, my lord, 90 days. Today it will be around, my lord,
Charge sheeted,
100 days, my lord.
charge sheeted,
No, it
Not
is not
first
chargeable.
It's a UAPS, their lordship.
UAP.
Lordship.
UAPS there and lordships have held, my lord, there is a judgment I had given the earlier day. In this same case, your lordships has held that section 43D does not get attracted. My lord. So if it does not get attracted, then my lord, it is 60 days and 90 days, my lord.
UAP is also ordinarily 90 days only on application of public prosecutor. If it is extended, then it will come. Is there anything of that sort in this case?
That
Even
If
kind of perusal of the FR also reflects there is nothing, my lord, of that sort, my lord.
the lordship in the.
What earlier order was passed?
Pardon, my lord. The earlier order, my lord, there's a certified copy I had given, my lord, perhaps.
On Indo Kolita,
Yes, my lord, yes.
in connection, the same case.
Same case, same affair, my lord. The lordships have held that, my lord, 43D does not apply, my lord. Even then, my lord, based upon Johur, my lord, London court, my lord, wanted to, my lord, go through once that CD, my lord.
So what is your date of arrest?
On 18/7/2025.
So it is now over 90 days.
Yes, yes, my lord. On 18/10 to, my lord, it was 90 days. From 18/10, my lord, it is 12 days and 7 days, my lord, 19 days more, my lord, 117 days to pay.
কিমান দিন হৈছে বোলে? 90 days above.
Oh, এশ 13 দিন।
18/7,
18/7 of it.
7 or 13, 9 or 13. Wait, yes. Lordship, then lordship, one thing I have to submit, lordship, if any extension prayer was made for the learned trial court, lordship, that I have to take instruction whether extension prayer is.
This is the order, my lord. Has your lordship got that order dated 19/9/2025, my lord?
Yes.
Lordship order is there. I am passing it on once more, my lord.
No, it is here, but in that case, we have held that there is no incriminating
Yes, my lord.
material other than statement of co-accused.
Yes, my lord.
But in this case, we don't know in his
It
case.
is here, my lord. Lordship.
It is here, lordship.
Yes. All right, you examine.
Yes, let him.
Koek is implicating him and other person, he is influenced the boys.
See two things. Firstly, see if there is the incriminating material, point it, flag it. And secondly, in case it is there, even then, 90 days is over. So in the absence of an extension order,
My lord.
result would be the same.
Lordship.
Already find it out and let us know.
Lordship.
Can it be taken up after that, my lord?
I'll flag out and deliver. the
Flag will pass order after that,
Yes, my lord.
So you can deliver.
after examining the CD.
My lord.
Second.
In case we find there is some material, then
Lordship.
we'll grant another date for getting the instruction regarding whether any extension order has been
The
passed.
CD in my presence so that I can also submit on that because what I am told is.
You are not
my
entitled
lord,
to see the CD.
pendency of, my lord, this case here, my lord, the learned trial court wanted to release him because that mandatory period was over, my lord. But because it was brought to the notice of the court that this is pending here, it was not done. So let him read the CD.
Which
and
court,
submit-
which court is this?
The court of the, my lord, session judge at Mongolway.
I think nowadays orders are also uploaded, so I think you
I'll
can get
flag
it.
mark it and deliver to you, lordship, lordship.
If no, I'm talking about any extension order being there or not.
That
So
yes.
let him see just.
If it is there in the magistrate's records, that you can see. When is the date that 90 days would be over on that date
Copy will be
or
here.
before that? Okay, call up the next item. You can see and you can wait for a while.
No.
I'm here for some time.
Extension prayer. 18/7 होता है is a completion date.
Yes.
17 lordship, we have received a case there, but PM report not available here, no? So we require a PM report, lordship.
There the petitioner is other family member, your lordship. Petitioner number one is a serious illness, your lordship. And 5 days delay of loss the FIR, your lordship. FIR is page number 8, your lordship. Very short FIR, your lordship. Kindly be perused, your lordship, page number 8. After 5 days of the incident, the FIR was lost, your lordship.
What is the incident?
103 is here.
It's a suicide incident, your lordship. After 5 days, colorfully lost this FIR, your lordship, by making false statement. There is a quarrel, your allegation. They have been reset separately from the husband family, Your Lordship. Husband also arrested, Your Lordship. Here petition number 1 is elder brother-in-law, petition number 2 is mother-in-law, and petition number 3 is co-village. 27 days in custody, Your Lordship. Further custody may not be necessary. On the same day, all are arrested. Husband also arrested, Your Lordship.
Necessity of custody depends on the gravity of the offense as well, not just that. And
At this stage, Your Lordship, kindly petition number 1 may kindly be allowed, Your Lordship.
What is your
He is
ailment?
Suffering illness, Your Lordship. Next, the medical documents, Your Lordship. Is number 13 to 30, Your Lordship. Also heart patient, Your Lordship. Serious condition, Your Lordship. Elder brother-in-law. Mother's also old age, 65 years. Petition number 2.
Sir,
Husband
the
also
M report, Lordship, which will reflect what,
resident, separate resident, Your Lordship. And
here is your
there is two
exercise.
children, Your Lordship, of this married, Your
Here
Lordship.
is your exercise stress test report. Good effort tolerance, normal BP response, no angina,
It's
arrhythmia.
cancer, Your Lordship.
So
Recently, Your Lordship.
your health is better than ours.
Recently, Your Lordship, suffering, Your Lordship.
only thing is that Lordship, going to the inquest report, PM report is not available here. Inquest report.
Do you
description of
even read the
injuries
medical
found on-
reports before
Yeah,
submitting?
bleeding from the back of the head,
Okay, have a short date.
Lordship.
Yes. CD not received. This is the matter again on
17, Lordship.
Lordship, there is another case fixed on 11, Your Lordship, of husband, Your Lordship.
same CD.
Lordship, on
Already 11 then.
same city. Case number is PA of 2000, sorry,
Yes.
3555.
List along with so and so.
BA 3455 of 25.
18
to 20.
Item number 18 to 20.
Apologies.
This one, ডাঙৰ আছে, by the blue color.
Wait, is it lordship?
Yes.
The person, this petitioner in 18-year lordship is behind the bars for last 32 days. Your Lord. The last occasion, the honorable court. was
What is the
pleased
matter
to
about
report
CD
the
received?
exercise and the medical report, the postmortem report.
Postmortem report is received, but FSL is pending.
What does postmortem? What is the allegation? Firstly, let's see the
allegation,
file.
Your Lordship, is that a person was assaulted by some persons and he succumbed to his injuries later, Your Lordship. Page 14 is the FIR. May I read, Your Lordship? With due respect, I, Sarita Razak, would like to inform you that yesterday, while returning from Durga Puja immersion, my brother Avinash Razak, alias Dhunu, aged about 28 years, was involved in arguing with some people who were dancing at Kalibari Puja Mandap, for which he was being.
Yes, what are the any injuries indicated?
Yes, Lordship, several individual pressure of abrasion size 1.5 cm, 1 cm with reddish cap, left side of face 2 cm below left radical region 7 cm away from midline, pressure abrasion of say 1.5 cm. Lots of injuries are there, Lordship. He was assaulted in a mob Lordship by in a Kali Puja during night, and several persons were there. So witnesses have stated that they cannot identify every individually, Lordship. But in CCTV footage, their implications are there. That's why they have arrested. But other witness said that some person, they have, these petitioners are present at the time of incident, Lordship.
I admit, Your Lordship, that
What is your name?
I am Your Lordship, in this, the 18 Binoy Kolita.
You are Binoy Kolita.
Kolita,
Then Biju, there is
Biju
another
Sil.
Biju Sil and Basan Basfor.
was for Your Lordship, in the, with respect to Binoy Kolita, Your Lordship, I have specific instruction that he was very much present, but he has not assaulted. And with respect to the other two petitioners, Your Lordship, I've got the instruction that they had tried to save the victim. But we have not assaulted them.
You have the CCTV pen drive then.
Yes, the pen drive is here.
Your Lordship, may kindly peruse page 16 for a moment. That will make
Yes.
it clear. Page 16, Your Lordship.
Yes.
There are two grounds of arrest, under the
Mhm.
heading grounds of arrest. May I read, Your Lordship?
During investigation based on statements of witnesses and previously arrested accused persons, it has been revealed that an altercation took place in front of Kalibari Durga Puja Mandap regarding a music-related issue with the deceased, who was not a resident of Kalibari. Subsequently, the deceased was brutally beaten by members of the Durga Puja committee and Jagriti Kongo Club together with his associates. The accused person number serial number 4 to 7. The members of the Kalibari Durga Puja committee were identified as the prime instigators who initiated the assault. Instead of intervening, they encouraged and incited the mob for about more than 20 persons, which led to grievous injuries to the deceased, who later succumbed to the hospital. At the hospital. So, Your Lordship, this serial number 4 to 7, Your Lordship, may kindly peruse, are different persons, Your Lordship. One Ratul Bora, Sujit Sarkar. These are the persons. Your Lordship.
Some witnesses stated that Sujit Sarkar, Vishal, Borun, Sandhu, they were seen at the place of, but who assaulted him exactly, specifically, they were not mentioned in the statement of the witnesses, Lordship. But
These number 4 to 7, they have been implicated.
some persons were implicated, Lordship.
As the forwarding report says, the accused
Yes.
persons at 4 to 7 being members of the committee were identified as the prime instigators who initiated the assault. They encouraged and incited. Okay, those are different persons from the present petitioners. So only the presence of the present petitioners at the place is indicated in the CD, is it?
Binoy Kolita, no? Binoy Kolita name is in the witnesses are stating about the name of Binoy Kolita. Bijusil name was not, I am not found. Vishal Chakraborty, Borun Vishal, Chandu, Chapon Sharma, and he is the petitioner Binoy Kolita Lanku. His name is several witnesses implicated him, Lordship, and he was present and involved in that part of assault.
This Binakolita.
Binoy Kolita.
What about Bijusil and the?
Bijusil name is.
Achha, you are not representing.
I am representing both Bijusil as well as the other person, Your Lordship.
Find out Bijusil and Vasan Vasford. Yeah, hard counsel for the
Bijusil
petitioner.
part is from no.
Learned additional PP.
Basanti's name is here.
This is an application under so and so. For bail, the
Basan Basfur alias Raja.
brief facts, paragraph 2.
Manna count, case of
Paragraph
MP.
2 of the bail petition, brief facts of the case. Heard Mr. T. Deori, learned counsel for the petitioner, who submits that the petitioner, although present at the place of occurrence, was not a participant in the assault. There are learned additional PP submits that the post-mortem report reveals multiple injuries on the person of the deceased, and also that there is incriminating material regarding participation of the present petitioner in the assault upon the deceased. Having regard to the above, the prayer for bail is rejected at this stage. Yes, what about Vasan Bijusil?
Bijusil name is not stating anybody Lordship, but Basan Basfur name is stating about the by the witness.
He is implicated.
Implicated Lordship.
Okay, item number 20, Basan Vasfar, same order. Okay. And item number 19. After post-mortem report. But it appears that there is no material implicating the present petitioner. Accordingly, the prayer for bail is allowed. Accused, the petitioner shall be released on bail of rupees 20,000 with one security like amount to the satisfaction of the learned Ilaka magistrate in connection with the aforesaid case. It is further provided that he shall cooperate with the investigation.
Item 21.
Bijusil to the
Oh,
Bijusil is
18, 19.
Oh, wait, no.
18, 19, 20 we are over.
Oh, Your Lordship, I thought only one order was passed. I thought only.
18 and 20 rejected, 19 is allowed.
I crave your Lordship's indulgence, my lord. In item number 16, I am just being told, my lord, that man has been released on default bail and he is out, my lord. So this petition has become infructuous. My lord, I may be allowed to withdraw it, my lord.
Yes. Which item was there? 16, I think.
16, my lord.
Item
16.
16. It is submitted that the petition has become infructuous due to release of the petitioner on default bail by the learned trial court, dismissed as infructuous.
I am to clear that.
May I, Lord? Lordship, in this case, Lordship, petitioner is in custody.
Before he starts, my lord, whether this matter is relating to NIA, my lord, that has to be verified. If NIA is there, my lord, then there is a standing council of NIA, my lord.
We'll verify that.
My lord, that in the first order, my lord, last order. The NIA case, my lord. So their name may be shown, my lord.
Who is for NIA?
I don't know. Architect should do it.
Yes, inform him if it is NIA. He was here during the morning.
Did they put NIA?
I'll inform.
Is a CD, who called for the CD then?
No, the scan copy call for, my lord.
Scan copy call for received.
Yes, sir.
Any order transferring the case to NIA? Examine.
That NIA court is there, my lord, there.
But UAP is there.
No, Lordship, it is Lordship only trafficking of person.
Huh?
Trafficking of person.
Trafficking.
Section 143(5) BNF. Yeah, I think Lordship. they are-
NIA does trafficking nowadays.
Lordship, she is in custody 6 months, 11 days today, Lordship. And other Lordship.
Anyway, let us first get things clear.
Yeah.
Examine the matter. If it's NIA, we'll take up after some time.
All right.
Also inform NIA council in case it's necessary.
Please, your lordship.
Yes, that is it.
You will find the FIR at page 13, that translated copy. First page. And behind the bar for 50 days, lordship. Mandatory period is 60 days.
What is the name of the petitioner?
Comrade Singh. Lordship, I have stated in para 5, page 4, that I have already returned the money to the persons from whom I have taken. And some portion of amount is left by.
That means the offense is proof, man. If is this submission is.
Because I was a victim of the circumstances, lordship. The main person is Nobojyoti, who has used me.
Is what is there in the CD?
There is sufficient evidence collected by the IO, man.
Today, it's 50 days, lordship, I am behind the bar. I was-
50.
On the ground of length of detention, lordship, is to allow.
All right, then investigation must be almost complete. by-
Investigation, my lord, some part of the investigation yet to be completed, my lord.
But anyway, he is in jail. You don't need him now.
He is in, my lord, and there are sufficient materials collected, my lord. That may be recorded.
Yes. Heard learned counsel for the petitioner. And heard Mr. J. Burwa learned additional PP. This is an application under so and so. Paragraph 2 of the bail petition, facts. Learned counsel for the petitioner submits that the petitioner was a victim of circumstances and having regard to the length of detention of 50 days undergone by the petitioner, he may be released on bail. Para, on the other hand, learned additional PP submits that sufficient material has been collected against the petitioner showing his involvement, and it has also been stated by learned counsel for the petitioner that the petitioner has returned the money which he had collected. Full stop. Para, having regard to the nature of the allegations and the length of detention, further detention, and also the progress of the investigation. Para, further detention of the petitioner is not considered necessary. Accordingly, 20,001 security. Satisfaction of learned Yalaka magistrate.
Let me watch. The charge sheet at case matter, and they 302. And the petitioner is behind the bar 173 days today, right? Charges have not yet paid. And your lawsuit file, he was arrested only on the basis of the co-accused statement, right? Investigation already completed, but the charge is submitted, whether further custody is required. In fact, my lord, he has gone to the marriage ceremony of the co-accused. And then he came back. Thereafter, my lord, that person was killed.
Where is the FIR?
FIR is page 14, my lord. Page 14.
CD received?
No, my lord, it's a
Oh, it's
certificate.
certificate.
Scan copy was called for.
Scan copy is called for, my lord.
Not received.
No, it
Yes,
is received, my lord.
Received, my lord. Accused number 1 and 2 stated my name. I am number 3.
Yes, what is the material against this Baharuddin?
My lord, they all together, my lord, all the three charged witness who accused person, my lord, they have killed the victim, my lord. And they kept buried them in the jungle, but later on his dead body was recovered, my lord. So at least, my lord, as per the last order, my lord, the case is fixed on 15/11/2025 for consideration of charge, my lord. Let the charge be framed, my lord. So that, my lord.
Will make to the point. Kindly see page 31, right? Page 31. Charge
So,
sheet.
my lord, it's a
What is the
charge sheet case,
basis
my
of his arrest, my lord? Page 31, the lordship will find that after registration of the case. The lordship got it. After registration of the case, I went to the house of the informant and examined under section so and so. During examination of the witnesses, it has come to know that since few days ago, hot altercation took place between the Salimuddin and Ahad. I am not neither of them. Asad has a computer shop nearby Salimuddin. Asad purchased a land from the Salimuddin, but Salimuddin claimed that Asad is trying to grab more land as agreement was made. So therefore a hot altercation was occurred between them. That time Asad warned him for dire consequences. However, on so-and-so, his wife said that he attended a marriage function of so-and-so, but at that time on the same day, few people have seen him, Zakir and Baharuddin, few days back. I am Baharuddin, man. At the Noya Bazar, after that, prior to the occurrence. So this is against me, my lord. Prior to days, I was seen along with Mother Elza co-accused in a bazaar. After the Salimuddin was missing, therefore he was missing, and people could not, they did not see Salimuddin at the Zakir wedding function. I have gone to the marriage ceremony, my lord, then I came back to my house. And I was all along there. After 3 months, I was arrested. Apprehended last trigger.
Other than confession of co-accused, there is, I think, some telephonic conversations, and
Yes.
those are also there. When is the case fixed for charge?
1511, madam.
Charge will be framed, my lord, because
Let us have this after that. After 15, who knows, you may be discharged also. Because we don't have the full details now.
yes, it is.
Lordship may call for this up-to-date status report, madam, after 15.
That we can also file if it is framed, my lord. We can also submit, my lord.
Yes, even if it is framed.
Yes.
So, Mr. H.R.S. Sudhiri, learned senior counsel for the petitioner, learned additional PP submits that the instant case is fixed for charge hearing on 15/11, 15/11/25 before the learned
Additional session.
additional session judge, which place Badarpur?
Sri
Bhumi.
Bhumi. Now Sri Bhumi.
Having regard to the above, place the matter again on,
Hello?
give a date after 15,
So to 21, madam.
19, my lord.
19,
We'll bring, my lord.
19, my lord.
19. In the meantime, call for the updated PCR as of 15
Well, only status report will. do.
status report.
Yes, ma'am. Because
Status
entire
will
case
be
case
already
diary has
come, my
come.
lord.
Okay.
Diary has come, my lord.
Call for a status report from the learned trial court as of 15.
As on 15.
As on date, my lord.
And petitioner is also at liberty, but we may also submit file.
Hmm.
We may also submit, suppose if for any reason it does not come to them,
Yes,
we can also make.
let you submit, but it has to be a certified copy.
That's. Oh, 19.
Okay.
Hold on.
In this case, I am for the informant.
Lordship, 60 days offence and 41 days behind the bar as of today, Lordship. Lordship will find the FIR, the translated copy at page 9, Lordship.
I received the case diary.
Lordship, the basic allegation against the present petitioner is that he has taken rupees 50 lakhs from few people, Lordship, in the name of giving jobs in the railway department, Lordship, but failed to do so. But if Lordship perused the FIR, Lordship will find at page in line number 3, Lordship, the accused number 2 introduced me to the accused number 1, that is Champa Kumar Bora, as an officer of the railway department, and the 2 accused met about 40 people whom I knew, that is the informant, at my house, at the informant's house, Lordship, and promised to give them jobs in the railway department. Accordingly, those persons collected the cash and handed over to me. Lordship, the 40 people were known to the informant. The 40 people met the informant at the informant's house, and the cash was also collected by the informant, Lordship. Therefore, very conveniently, the informant has implicated the present petitioner in this case.
Witnesses' statements were recorded because they have implicated the petitioner. The petitioner took several amounts of money, Lordship, a huge amount. Someone from 12,50,000, someone from 3,50,000, someone from 4 lakh to providing job in railway department also. Several persons were there, they were victimized to getting job and.
By these 2 persons, Champak
Yes.
Bora and Nilamani Nath.
Nilamani Nath.
Yes, informant. Where did you get so much money? Where
And
did
it
you
was
get
a-
so much money
Have been,
Huh?
my lord,
to pay 50 lakhs?
not from me, lordship. In
What?
my presence, lordship, it was done, lordship. So, my lord, he is my lord, habituated, my lord, with such a sitting lordship.
You said accused number 1 took 50 lakhs from me, and accused 2 took 30 lakhs.
My lord, in my presence.
You have
lordship,
80 lakhs. You pay income tax.
My lord, in my presence, no, not from my.
No, your language is
I am
that.
a commander, lordship. In my presence, my lord, it was taken, lordship. My lord.
Then why are you so?
Lordship.
Why are you aggrieved?
My
If
lord,
it's not your money.
My lord, someone is my relative lordship. That is why lordship. My lord, in an my lord, application my lord, before the IU lordship, it was my lord. He undertook to my lord pay back the money lordship.
What is that?
My lord, the accused my lord undertook to my lord, pay back the money lordship.
Nilamani Nath.
He is a Sompok, no. He is a Lord Sompok
Kumar Bora.
Kumar.
He introduced himself as a railway officer.
So shall we forward a copy to the income tax department to investigate the source of the funds? If it is not your money.
I am not really employed.
Had
lordship. I
learned
am
counsel
my
for the
lord,
petitioner also had learned additional PP. Mr. So and so appears on behalf of the informant. This is an application under so and so. The allegations as contained in the FIR is that page 15 of page 15 forwarding reported brief of the case, please. On para. It is submitted on behalf of the petitioner that the petitioner has spent how many days?
41 days.
41 days in custody. And the prayer for bail may be considered on account of the length of detention. Para, on the other hand, learned additional PP submits that the present accused persons have fraudulently obtained money for the purpose of, on the promise of securing them jobs in the railway department, not only from the present victim, but also from many others, as revealed by the CD. Where, and the amount involved is also huge. Full stop. Having regard to the seriousness of the allegations and the incriminating material available in CD, the prayer for bail is rejected at this stage. Send back the CD. Okay, we don't need this one now.
Lordship, I'm sorry, Lordship. In item number 21, Lordship, I have contacted with the NIA council, Lordship, but he was not there. Lordship, can I fix this matter? Can you, your Lordship, may fix this matter on 12, no? 12, Lordship. In the meantime, I'll serve a copy to him also, and if the matter is listed.
So you ascertained if this is NIA.
The case has been transferred to NIA.
There is an order, I have just 5 minutes.
All right. It is submitted by learned counsel that the present case has been transferred to NIA. Learned counsel for petitioner submits that he will serve copy upon learned counsel representing NIA within 3 days. Yes. Please the matter again on
12,
The name of the
showing the name of standing counsel NIA in the cause list.
Lordship, it is not
21.
transferred to NIA, Lordship.
Oh.
Lordship, it is not
26
transferred
to
to
delay.
NIA.
It 21 delay. 26 to dia hoy gol.
26 coming.
26 আরম্ভ হইব না না?
26.
May it please the Lordship. Number 26, 27 and 28, Mother. They are same person but different cases, Mother. Here, Mother, the petitioner are behind the bars in 26, Mother, for 58 days. Allegation is, Mother, regarding, Mother, theft of some Mother, jewelry and other material from a temple, Mother.
26, 27, 28 nahi.
26 is Nur Hussain.
Nur Hussain and
Your purchaser.
Purchaser. Nur Hussain is the purchaser, my lord. Nur Hussain is the purchaser. 58 days in custody, my lord. And pray, my lord, further detention may not be required. And my lord, 27 and 28, my lord, he is also Nur Hussain, same person, my lord, but different cases.
Okay, let us deal with 26 first.
26.
Yes, PP.
Yes, but he
There must be material.
after he bought up stolen ornaments, Lordship.
Hard learned counsel for the petitioner, learned additional PP. This is an application under so and so. The allegation against the petitioner, present petitioner, who is a jeweler, is that he purchased stolen property from other co-accused. Full stop. It is contended on behalf of the petitioner that the petitioner did so unknowingly and had no knowledge about the theft. Where learned additional PP submits that there is sufficient material against the petitioner pertaining to purchase of stolen property. Full stop. However, it appears that the petitioner has already spent 58 days in custody and the investigation of the case has also progressed. Where having regard to the above, the prayer for bail is allowed. 50,000. 2 sureties. Ilaka magistrate. Condition cooperate with the investigation. Yes, next is 20.
28, 27, my lord. Here, my lord, 68 days, my lord, in custody.
But who are you?
But of course, Noor, my lord.
Same person.
Same person.
In another case.
Another case, 28 also another case, my lord. Allegations are.
So it is not charge sheeted.
No, not such.
27, we have not received a case diary in this set, Lordship.
But statutory period is over.
But because my lord, regarding my lord, Noor Hussain's statutory period may be over, my lord, because he has not done, my lord. If there is
305 and 331, 90 days.
314 is 90 days, my lord, because 14 years, but he has not committed, my lord, the Noor Hussain. He has only part.
Oh, let us see what is the case against this one. Where is the FIR?
FIR 8, my lord.
Different FIR.
Different FIR. FIR 8 pays, my lord, 12, my lord. And page 17, my lord, the allegation against my lord, Noor Hussain, my lord. Page 17, my lord, is the allegation against Noor Hussain.
What, page 17?
Page 17, paragraph 7, my lord.
The ornament shows sold at the jewelry shop of Noor Hussain, Lordship. He purchased the that.
So in this case also, you are the purchaser.
Yes, Lordship.
Noor Hussain is the purchaser.
Were you shown arrested in this case?
So, my lord, actually, here, my lord, in item number 27, he was arrested. In 26, he was shown arrested, and 28, he was shown arrested.
So 58 days from shown arrested in the earlier
No,
case.
if he, in the May, 58 days from shown arrested, and main case 68 days, my lord.
68 days.
After detention may not be required.
So same material against him.
Actually, that
CD is not there.
available here. We have not received the case
CD
diary
is
of
not
this.
available. Okay, then wait for some time.
My lord, 68 days in custody, a lot. Further custody may not be required because he has purchased it. It is from the apparent from the forwarding report. He has 68 days in custody.
By looking at the face of the seller, he knows what the property is actually.
Lordship is correct, my
So-
lord. That
Let us wait for a few days. Yes. When can you have?
18, Lordship. 18.
18, all right.
And item number 28.
28 also, my lord, same, my lord, same.
20,
All
in
right,
this
same
case,
order, CD.
so in this case, charge sheet submitted.
So SAR sheets of 27, CD not received, wait, who's taken on it. 28, what, SAR sheet?
Charge sheet submitted, Lordship.
Lordship 27, lordship, he will cooperate, my lord, the remaining.
So since we have fixed 27 for CD, we'll call for the TCR in this case.
Lordship.
28, it is submitted, the charge sheet has already been submitted, call for the scanned copy of the TCR list again on 18 along with bail application 3472 of 25.
Lordship.
Apply, your lord.
Madam?
Wait, Your Lordship. My lord, here, my lord, CD was called for, my lord. Petitioner was, my lord, initially arrested in one case, my lord, and subsequently,
Receive.
We have not received a case diary, Lordship.
and here, my lord, specific plea of the petitioners are that, my lord, notice was also not served upon.
Anyway, we have to see the CD for that, otherwise.
One is from Lordship, Hillshore PS case number 864. Both signature.
Not, oh, okay, one is Dhalai, 106.
Already, CD not received. List again on.
One of the petitioner is very serious.
Give a short date.
Ailment, my lord.
Short date, Lordship,
Actually, my lord, they have
17.
could not find the actual culprit and to show the, my lord, higher authority, innocent person kept in jail. I do not already do.
Keep the blood. May I please? My lord, item 30
Received.
out of the same affair. My lord, diary was called for, my lord. My lord, what happened? Both the parties lost cases against each other, my lord. I am behind the bar since 28 days, my lord. Perhaps investigation also subsequently progressed, my lord.
What is the allegation?
My lord, allegation is under section 192, 192(3), 126, 117(2), 3042, 108(2), 118(2), my lord. The FIR is at page number, my lord, 10. Specific allegation against this petition.
Injury report is there.
The injury report, my lord, the fracture is there, my lord, but the specific injury report is not available, my lord. The X-ray was done, my lord, and the fracture of the, my lord, elbow joint and LAT, AP, my lord, that is there, my lord.
Perhaps investigation subsequently progressed of the custodial.
What?
28 days. I have behind the bar since 28 days.
Item number 31 is BA, my lord, and 32 is AP.
Any specific implication of
The witnesses implicated, my lord. The witnesses
which one?
implicated-
Habezuddin?
Witnesses implicated 3 persons, my lord. One is, my lord, Habezuddin. One is Mogreb Ali, my lord. Mogreb Ali, that as per my lord, witnesses statement, my lord, Mogreb Ali assaulted with Dow, my lord. And one Mohammed Ali also assaulted. And Habez Ali also assaulted, my lord.
There is no cutting. If how is used. Cutting is.
All the accused person, they have implicated all the accused person, and apart from that, my lord, these 3 accused persons, my lord, they have caused the injury, my lord.
I am also suffering from some eye. I cannot move. But that is happening.
And what about 32 petitioners
32,
therein?
my lord, there are around, my lord,
10 petitioners.
my lord, the 10 accused person, my lord. They are also named in the FIR, my lord. And out of the 10 petitioner, my lord, the Mogreb Ali is there, my lord. Against whom, my lord, the witnesses is implicated, my lord. And one Momin Ali, my lord, I have Momin Ali is petitioner number 2, my lord. In the FIR, my lord, all the accused persons was implicated. my lord.
But a specific allegation only Mogrobali and Momini. Was the FIR. Only Mogrobali.
Mogreb Ali assaulted with Dow, my lord, and Momin Ali assaulted with, my lord, on Batam, my lord. Then Batam.
It heard learned counsel for the petitioner. So heard learned additional PP. This is an application under so and so. Paragraph 3. Text. Learned additional PP with reference to the CD submits that the petitioner has been implicated by the victims.
By the, my lord,
Okay, by the witnesses.
this is my lord.
The injury report reveals fracture on the hand of the victim. One of the victims. Number of persons were there, I think. The victims on the other
Victim
hand,
is the wife of the informant, my lord.
the victim, that is the wife of the informant. On the other hand, learned counsel for the petitioner submits that having regard to the length of detention, the prayer for bail may be allowed. You have also filed an FIR.
My lord, page number 16.
Further, it
Both sides are there as in.
it is submitted that a cross FIR had been
Page number-
submitted by the present petitioner side against the informant side of the present case. Making similar allegations of assault. Full stop. Having regard to the having regard to the period of detention and also the stage of the investigation, which appears to have progressed as revealed by the CD. The prayer for bail is allowed. $20,000 surety. Condition cooperate with the investigation. Will not try to influence or intimidate witnesses.
That injury report not received, that may be reflected, my lord.
Then what is received?
No, my lord, there is the X-ray report, my lord.
X-ray report.
X-ray report, my lord. Where is it shows, my lord, the bones, fracture of the bone, my lord. Injury report, my lord, that is, my lord, given by the medical authority, my lord, that is not.
All right. Yeah. You put in there, injury report is not received, but X-ray report is available.
In other case, my lord, there are allegations against, no, my lord, ultrasound, sir. 32 at all.
Yes.
Other case, my lord, there are materials against accused number, petitioner number 2, my lord, Momin Ali, and 5, Mogreb Ali, my lord. Although, my lord, the
With same order,
this
just
is taken
change
all the
that
person, my lord.
main paragraph that it is submitted by learned PP with reference to the CD that there is material in the CD against the petitioner's number
2, Momin Ali,
2 Momin Ali and
petitioner number, my lord, 5, Mogreb Ali.
5 Mogreb Ali. However, there is no direct implication with regard to the rest of the petitioners. There are having regard to the above, the prayer for pre-arrest bail in respect of petitioners number 1 so and so and petitioner number 5 so and so is rejected. The prayer for pre-arrest bail in respect of the petitioners number 2, 3, 4, 6, 7, 8, 9, and 10
One also.
are allowed. No, 1 and 5 material is against 1 and 5, 2 and 5.
2 and 5.
2 and 5 rejected, rest allowed.
Lordship, I have a humble,
I'll agree.
Lordship, I'm a humble, item number 26, Lordship. We have only deal with only one petitioner, Noor. There are two petitioners,
Still there are
Noor and Tafazul.
At that time, my lord,
Tafazul of.
submit, my lord. I was
Just a
taking-
moment, let me complete this.
Lordship.
This provided that the event of their arrest, the petitioners number 2 and 20,000, 1 Yes, what happened to 26?
I'm very sorry, my lord. At that time, my lord, thought he was regarding, my lord, one petitioner. There is another petitioner, my lord.
Tafazul Haq.
Tafadhul Haq.
There are materials against him. He has committed the offense. The theft part was done by these petitioners, Lordship. Tafazul Haq.
Okay, item 26 order.
26.
Doctor.
There are two petitioners. One we have granted.
Okay, just a moment, item 26. একটু ডটক নিজে লৈ আনিব দিব ফাইলটো লৈ আহিম That's petitioner number 2.
Two lordship, yes.
The number 2.
Okay, we'll see.
I'm very sorry, my lord. Oblige, your lordship.
Yes.
May please, your lordship.
Yes.
Your lordship, here is believed to be from Malad. This was called for, but after this CD was called for. We have not received the up-to-date CD, lordship.
Received.
Not received.
Up-to-date CD not received. List again on so and so interim to continue.
Interim of the-
There is an interim order.
Yes, interim to continue till next date.
21/11, lordship. This is also search sheet submitted. Search sheet submitted, lordship.
There is on interim lordship.
All right,
Relation
it
of
is submitted. The charge sheet has already been submitted. Call for the scan copy of the TCR. Interim order passed earlier to continue till the next date.
Lordship may dispose it of by directing the petitioner to appear before the trial court, that interim may be continued for 15 days, he will appear before.
All right, then, our learned counsel for the petitioner, it is submitted. That charge sheet has already been submitted. White charge sheet number.
110/25 dated 23/8/25.
It is submitted on behalf of the petitioner that they will appear before the learned court below and file appropriate application. Echo full stop accordingly, it is provided that the petitioner shall appear before the learned court below within a period of 15 days from today and file appropriate applications as may be advised, which shall be considered by the learned court below as per law. Till then, the petitioners shall not be arrested.
That interim order. Interim order.
Till then, the interim order passed earlier to continue.
Oblige.
35, lordship. Same prayer, lordship, is a interim and search sheet submitted.
You'll appear.
Same.
Malad, interim is there. Malad,
You'll appear.
Yes, ma'am.
15 days. All right, same order.
Search sheet number 103/25 dated 30/8/25.
Oblige.
Interim is there, no?
Interim is there.
Yes.
May it please. My lord, postmortem report was called for. Allegation is abatement of suicide, my lord.
Postmortem report is here, lordship here, but final opinion regarding the cause of death is pending, lordship. FSL report we received, no poison was found, lordship. Only thing is that going to the case diary, witnesses said that the deceased victim was to pay to the house of the petitioner's lordship and on 11/7/25, and he was physically and mentally tortured by this petitioner and he was sent back to her home. And later on his on 12/7/25 in the morning time, she committed suicide.
We committed suicide at Barpeta, my lord, and my residence is at Bongaigaon.
Some of the orders stated that he was threatened to file some sin photographs of her lordship. Photographs and videos. Going to the case, there is a statement of the witnesses, lordship 108 is indicating the petitioner, lordship. Abatement of suicide.
Yes, counsel, there appears to be
My lord, but
sufficient
as per the
material
FIR,
against.
my lord, if she was hurt seriously, her brother took her home instead of taking her to hospital, my lord. In the FIR, it is alleged that she was hurt severely by me.
But
to
there are other allegations against you as well. That is not the only one.
Those are allegations, my lord.
At this stage, there can only be allegations. What else is there? Already pass on the CD. Let's have a look.
I'm appearing informant.
Yes.
This training part is there.
Hmm?
Intended part is there, your lordship, as portion FIR.
Hmm.
You, and also, if he disclosed this matter, then he uploaded the social media private photo.
Hmm.
In this regard, he commits suicide.
Okay, abatement is clear.
Yes.
Yes.
I flag marked up relevant.
Right.
Wait, please, lordship. In this case, my lord, interim, I've been allowed to go on interim bail, my lord. The allegations against me, my lord, I was my lord, a tea garden was been allowed to, ATC was allowed to run by me, and I have given an order, my lord, for my lord, repairing of this item, my lord. And he repaired and bill has been submitted to me. I said that this is a matter related to Assam Tea Corporation, my lord. So give the bill, I will help you, my lord. Now, he is not getting the bill, and for that, he has filed this FIR. The purely civil matter.
Who has not given the bill? No.
Look, it is, actually the garden belongs to Assam Tea Corporation.
Yes.
And I was allowed to run the garden. And for 6 months I ran, and thereafter I handed over the garden. While the garden has been handed over to me, Willard, I told that these are the things to be repaired. So they said that, okay, fine, you repaired, and the bill has to be given to the Assam Tea Corporations. The complainant is the engineering works who repaired, and they are, repaired the machineries, Willard. And the bill has been, it is on the record, Willard.
Yes.
Lordship, one humble submission only I am having.
And before, prior to that, Millard, he has filed an affidavit. Millard, I don't know, in the bail application, he has filed an affidavit without taking permission from the court, whether the court has allowed him. There has to be, Millard, the court has to allow him, Millard, for filing of these things, whether he has taken these things.
My lord, in this case, my lord, we have received the case diary, my lord, and by order dated 11/8/2025, my lord, this honorable court granted interim bail to all the accused persons, my lord. But my lord, except the petitioner number 1, my lord, other accused persons, they have not appeared before the IO, my lord. So may I pray, my lord, they have not, my lord, they have violated the honorable court order, my lord, by not appearing for the investigating officer to cooperate with the investigation, my lord.
It's not that, Millard. Everybody has appeared, Millard. Everybody, I said that everybody has appeared.
Their
Millard.
statement is not in the case diary, my lord.
That is
Except
why,
one
Millard,
person.
that is why earlier, on the earlier occasion, the same Millard has been given to that, and they said it has been sent to for a up-to-date case diary, Millard. I said that all we have appeared, Millard.
So is it an up-to-date case diary?
The case is not, it is up to my lord 2/9, my lord.
So it was, I see the earlier,
Last order was on 1610.
my lord,
But till that, my lord, the one person appeared, my lord, while the other person has not appeared, my lord.
that is in the month of September, Millard. It has appeared, thereafter it has been appeared, all
Then,
this
my
have
lord,
been
we'll call for
appeared.
the
They are-
update case diary, my lord.
See, last order was for calling of up-to-date case diary since the statements of the other petitioners are not available. That was on 1610. So after that, have you received the case diary?
No, it has been kept here only, that is.
No, my lord, that is not up to date, my lord.
Then
So without having up to date, Millard, he has,
pursuant to order dated 1610/25, up-to-date case diary has not been received. Call for up-to-date case diary, including the statements of the petitioners that may have been recorded by the IO in the meantime. All the statements of the petition, statements of all the petitioners, okay, may have been recorded.
the one already been there, 2, 3, 4, Millard.
28/11, my lord.
2811 interim order passed earlier to continue till then.
Next.
May I please your lordship? My lord, here petitioner was released on interim bail, my lord, and his statement was recorded, my lord.
In the FIR, my lord, my name is not mentioned in the FIR, my lord. I am working as a dealing assistant of the my lord DT office, Bongaigaon. Now I am in my lord Mongoldoy, my lord. As per FIR, my lord, one Apurva Kumar Burman has said, my lord, that he has sold the vehicle. I am reading that FIR, my lord, first paragraph, my last part. But the original owner, Apurva Kumar Burman, informed that he had not sold the vehicle to anyone and the vehicle is still in his custody. On examination of files, so-and-so Rafiqul Islam has found, my lord, a document has been produced, my lord, and when it was verified by the MBI, my lord, it was mismatched, my lord. Lordship, kindly come to the, my lord, case, my lord, 21, point number 14. A copy of the, point number 40, copy of the original notary agreement for sale containing the pages between seller Apurva Kumar in person and purchase Rafiqul Islam bearing sale number so-and-so, so-and-so. My lord, I do not know what is in the case diary, my lord. As per my instruction, nothing has been entered. My IP is not uploaded, my lord. After uploadation of the document, it is the duty of the MBI to verify that my lord document as well as the vehicle, my lord. And DTO has given certificate approval, my lord. How I was involved, I do not know, my lord. Police is searching me, that is why I find the bail, please.
Your name is?
My name is Subodh Chaudhary. My name is not mentioned in the FIR.
What is there against Subodh Chaudhary?
My lord, he was the, my lord, senior assistant at that point of time, my lord, and without verifying the records, my lord, he put up the file before the DTO, my lord. And this is the report of the investigating officer, what, my lord, what has been revealed as on that, my lord. Lordship, may kindly peruse paragraph number 3, my lord.
My humble submission before your lordship is that suppose there is a negligence of duty, I put up the file. Who will verify, my lord? And document I have shown, they have
They
produced
conspired, my lord, along with the other accused person.
anything, my lord, that may be mentioned, my lord, but my humble submission before your lordship, suppose, my lord, document has been put up. Who will verify, my lord? And whole case is based on documentary evidence, my lord. All the document has been seized, my lord. My statement has already been recorded, my lord. And now at this stage, whether custodial interrogation of the petitioner is necessary, my lord, I am relying on judgment, my lord.
According to the IO, it is.
My lord, lordship, kindly go through the, my lord.
Because there is a larger gang in operation involved in this
They dealt with, my lord, stolen bike, my lord.
dealing
My
with.
lord,
Yes.
it was 22. I was in Dow Mongoldoy, my lord. At that time, my lord, that is why the document has been placed before me, my lord. My lord, it was not, my lord, uploaded through my IP address. Your lordship, kindly go through the document, my lord, as per my instruction. It was uploaded by the Boro Baro. Allegation against me that we have forwarded that document, my lord. Does it mean, my lord, DTO has not, Leol, my lord, MBA has not, why my custodial interrogation is necessary, my lord? That is my humble submission. And whole case is based on documentary evidence, my lord. At this time, a fact error of my return of service, my lord.
You were in this case pertains to Pokradal.
I'm in Mongoldoy, my lord.
No, early, when were you in Bongaigaon? Till what time?
I was in Bongaigaon, my lord. Good election again.
You don't know.
I don't know, man. No? I think at that time I was in Bongaigaon, my lord.
Okay, you were in Bongaigaon.
At that time, I think Bongaigaon. My humble submission before your lordship, why my custodial interrogations, all the documentary evidence, my lord. Document has been seized, my lord.
All right, we'll see.
And my statement has been recorded, my lord. And yes, my lord, one important page 21, my lord. Description sheets provide the MR 47. One copy order sheet, note sheet, order of DTO Bongaigaon in favor of Archers Apurva Kumar Burman. DTO has
Yes.
verified all these things, my lord.
Page?
Case 21, description of this article, para 1, my lord. Just 14, sorry, my lord, below, just 14 below, my lord. Every DTO has been done, my lord. And vehicle has been verified by the MBA, my lord. And incident took place 2020. This case is squarely covered, my lord. Judgment has been given. And FIR was filed on 25, my lord. As per FIR, my lord, incident was 2020. FIR was filed on 2025, my lord.
Incident is of 20.
20, my lord. And FIR filed on 2/8/2025, my lord. After 5 years, my lord. I'm going to retire from my service, my lord.
Yes.
19 of that judgment, my
All right, we'll see.
lord. Yes,
My objection may be recorded. My lord.
Yes. Receive.
Yes, then he received, my lord. The accused person, he appeared, my lord. Actually, he is the owner of the shop, my lord, where he, my lord, his arms are recovered, my lord. And the allegation is that, my lord, his employee, my lord, he kept the arms, my lord, given by somebody else, my lord. It was recovered from his shop, my lord. That is why, my lord, apprehending arrest, my lord.
Earlier also, Lordship, he was arrested and subsequently he released on bail, Lordship. In that
In
particular,
the same case.
in a different. In that
Yes,
particular
yes, this
case-
Hanuman Pandya,
Yes,
this fellow keeps coming. Earlier also I have dealt with, remember the name.
Yes, my lord. That maybe in connection with some other case.
in this connection, the charge sheet has been laid, exonerating discharging him, Lord, in the earlier case.
In the present one.
In the earlier case, when.
Present case investigation is pending, my lord. Otherwise, not sufficiently progressed, my lord. He has appeared statement recorded. my lord.
Heard learned counsel for the petitioner and also heard learned additional PP. This is an application under so and so allegation against the petitioner. Paragraph 2. It appears from the CD that the investigation has progressed sufficiently. And the petitioner has appeared before the IO and his statement has also
Recorded.
been recorded. Considering the above, the custodial interrogation of the petitioner. May not be necessary. Accordingly, the order of interim pre-arrest bail dated 19/9/2025 is hereby made absolute.
My lord, he may be directed to cooperate, my lord.
Petitioner is on the absolute on the condition that he shall cooperate with the investigation. Shall not. Okay, he shall cooperate with the investigation. The order dated 19/9/25 for narration to us. Sorry, for I need to go para. Taki chini milai dile ho.
Wait, please, your lordship.
40 case that is not received today, my lord.
Lordship, informant is the father of the petitioner, lordship. Lordship, kindly see FIR at page 8, lordship. Here are two accused persons. Accused number 1 is the brother of the informant, who is the son of the informant. There was a quarrel between the informant and the accused number 1, between two brothers. And
Whatever, for whatever reason, you were not granted interim earlier.
it is from Komalpur, lordship. This is for the second occasion, lordship.
Yes, next to a candidate. She did not receive police.
20, my lord. 20.
Obliged.
Your lordship, it has been filed.
CD,
Search it has been filed here.
charge sheet. What to do? None appears. List again after. List again on next week date.
May I please, your lordship? But the CD was called for and I was on interim, I appeared before the IO and my statement got recorded. Lord.
Yeah.
Lordship, I have gone through the statement of the victim, lordship. And accused statement, lordship finally perused.
Third learned council petition. Learned additional PP. This is an application under order dated 17/10/25. Same para 1, 2, 3. CD as called for has been received. And a statement of the victim girl is available and recorded under section 164 CRPC is available on 183 BNSS, sorry. BNSS is available in that CD. Wherefrom it appears that she had been in a relationship with the accused because of a love affair, which included physical relationship. Full stop. It has been held by the Honorable Supreme Court that in cases where a mature woman maintains physical relationship with a person for a number of years from a no element of cheating can be said to have been made out. Having regard to the above, the prayer for pre-arrest bail is allowed. The order of interim pre-arrest bail dated 17/10/25 is hereby made absolute on the same conditions. Bail petition stands allowed, disposed of accordingly. Send back the CD.
Valuable.
Matt is a lordship. In this case, PD Kedari of Juria PS case number 201 of 2025 and 202 of 2025 were called for.
Lordship, we have received only one CD that is in respect of Juria PS case 202/2025. The another CD is still awaited, Lordship.
202 means this case.
Yes, Lord.
Why was the other case called for?
In-
Cross case.
Yes, in the earlier occasion, both CDs were called for along with the postmortem.
PM is there.
Oh, Lordship,
PM report.
PM report, Lordship, actually, in fact, Lordships, since the other CD is not available, I have not gone through the present state of case, Lordship. Let
What
me
is the
check.
allegation basically?
Let me check, Lordship, whether the postmortem report is available or not. And Lordship, here the cause of death is kept pending because of the receipt of Visara, Lordship. If your Lordship permits, then if your Lordship is satisfied with this case only in respect of Juria 202, then I'll go through after some time. If another
Right, why did we call for the other case?
Lordship, in the earlier occasion, I was not there.
Maybe a cross case. I think.
Yes, Lordship. 201 is the earlier one and 202 is the subsequent FIR. So earlier FIR is not before, the CD is not before us. That is 201. That will, Lordship, will.
What do you want? Should we wait for the other CD or should we decide on the basis of the present CD?
Lordship may kindly give us time, means next date.
Next date means what we call for the remaining CD.
Yes,
That
Lordship.
is- If it's not to be today, then we'll call for wait for the other CD.
Yes.
All right. It is submitted by learned additional PP that the CD of Juria PS case number 202 of 25 is available, but the CD of Juria PS case number 201 of 25 has not yet been received. PM report is available.
Not available. Lordship.
Not available.
Not available. Because of, it is the cause of death is pending because of.
PM report is also not available. Rest of the report is also not there.
Lordship, yes,
It simply stated that it is kept pending.
yes.
PM report is also not available. In that case, we cannot decide anyway because of hence issue reminder to the IO to send the CD as well as the PM report in respect of Juria PS case number 202 of 25. Send the CD in respect, I got to the CD of Zuria PS case number 201 of 25 and PM report in respect of 202 of 25. Okay. List again on.
Lordship, whether we should keep the present or we
Yeah,
should send
I
it.
think better keep it.
Not
Is it? CD,
24/11.
CD received be retained till the next day.
Yes, Lordship.
Here in this case, I am not the FIR named accused. Just a quarrel took place in a neighbor's house. I was unfortunately present there. So I am just apprehending. There is no allegation against me. There is an allegation by the informant against some unknown person because she was blindfolded and she could not see anything. But she is under assumption and presumption lost the FIR against some unknown person and named someone. But I am not the person whose name is there in the FIR. Just I am apprehending because I received a call from the police station. And for this simple reason, I have filed this anticipated bail. I have been protected by the last order passed by this honorable court, and today the CD was called for. Perhaps it has come.
Did you appear or not?
Well, I appeared. Before the IO, recorded my statement. I am ready to cooperate if there is anything against other accused to unfold the actual crime that has allegedly taken place.
Lordship, I have gone through the statement of the present petitioner. So I have found sufficient materials against him and he himself admitted that his complicity is very much there in the Alice crime. Lordship kindly goes through his statement. Along with the other accused, that is in respect of item number 47, Ranjan Mondal. Yes.
This is 45.
44.
44.
This is 44.
My name is Sanjeev Saha.
Yes, Lordship. He has specifically stated his involvement in the Alice crime.
I have not seen whether it is involvement with the poison or involvement in the place of occurrence.
Poison?
Allegation.
Poison.
Apparently it was
Yellow.
yellow color substance.
It's not poison. That was not.
He was made senseless.
It was not administered.
Yes.
He just smelled it and she became unconscious. That was not administered.
But unfortunately, section 123 has been invoked here.
And Lordship may kindly go through the FIR first, Lordship.
Section 123 does not even attract in this case.
This is accused number.
In item number 44, Sanjeev Saha.
I am not the
yes.
accused here, Balaji.
He is not named in the FIR, but he has
voluntarily entered that.
Yeah,
That means
he has come into the picture
I have
very
given my
clearly.
confession before the police and I
That
am
is
ready
very
to cooperate.
specific, Lordship.
because
And Lordship also go.
mention some unknown people also.
Yes, also may peruse the statement of another accused person, that is in respect of item number 47, Lordship. He is Ranjan Mandal, who is also,
Ranjan.
yes, Ranjan Mandal. And all other statements here, Lordship, may peruse. Everybody is implicating the persons. And he himself admitted. Oh, he is there to compose.
I have not seen the Malad. I am not authorized also to see the CD, but as understood, Malad, if he has confessed then very well, Malad, then he will face the trial. No more investigation is necessary in the case then, Malad.
No, it's not a fit case for granting
The
impunity.
violation of fundamental right, Malad, Act Chanda case is very clear. 2012
That
one
is in
SSA page
respect of
40.
bail, Lordship.
But it's only bail, my lord.
Is
For
it
the bail,
is
my
at the
lord.
discretion of the court? That
But
is
discretion,
anticipatory bail is not.
And that's why, my lord, I'm submitting, my lord.
Lordship.
Just to use the discretion, I'm not, my lord, saying that a bail should be granted,
It's
but the
up to your
criteria,
lordship, but there are very much
but the criteria to grant bail,
materials,
my lord, should be
sufficient
considered,
materials
my
are
lord.
there against a petition.
Yes, I'll face trial. I'm ready to face trial.
That is up to your lordship.
Okay,
My
we'll
lord,
see.
bail is not a punishment. Bail is, my lord, to ensure that the accused appear before the trial court. Just to ensure that, my lord.
My lord, I am for 47, the lordship.
Yes.
Here, my lord, one line allegation is that, my lord, the informant called me, my lord, and my lord, I threatened her. In the FIR itself, it is written, no other allegation.
I have got no objection in respect of accused Ranjan Mant.
Ranjan, my lord, there cannot be anything, my lord. He appeared, his statement has been
All
recorded.
right. 47.
But-
Learned.
But there was no interim, my lord. Lordship might remember, my lord. was granted to him.
Another accused number, that is accused number 2 in respect of item number 47. There is a sufficient materials against her.
There is no interim also.
Which one?
Item 47,
Item-
accused number 2, Uma Mant,
Lordship has not granted interim also to her, my lord.
wife of
He's
Ranjan
the
Mant.
main accused, I think.
Yes, wife of Ranjan Mant. This is the main accused along with Sanjeev Saha, lordship.
But Ranjan, there is nothing, my lord.
Sanjeev Saha, he himself involved, lordship.
But that's why, my lord, I am fair to the investigation. I will participate in the
If
trial.
materials are there, lordship,
My lord,
how
if-
can
my
lordship?
lord, the not granting bail, my lord, it's not a punitive measure, my lord. Granting bail, my lord, just to ensure that the accused appear before the
My
trial court.
duty is to.
Yes,
It is
next.
not by way of punishment.
Oblige, your lord.
Well, 44.
Buffer to you.
Chamber.
In this case,
Dear lordship, Sarsit has been late.
Hmm?
Sarsit has been late.
Charge sheet.
Yes, lord.
What do you want to do? Want to appear there?
I may protect my lord.
Lordship, only one thing, whether the victim has been recovered.
We go back, this is the matter.
Let him appear before the trial court, lordship. Trial court will decide in accordance with law. lordship.
Victim, my lord, actually what happened? The voluntary return back to home. There is no kidnapping, my lord. Even section for this.
No, any petitions, 137 2. 137 subsection 2.
She has not come with us, my lord. I am a married person. He is my grandson, granddaughter, my lord. And that order has not been reflected by the London Sessions while rejecting my bail applications.
137 subsection.
Ilosmo Kalisi Annexure 2, page 14, rejection order. This order, that order should be reflected. Her statement has been recorded on my lord 11/9/2025.
And
And
in the
rejection
order,
order is 15/10/2025.
and in the order,
No
it's that lordship,
parents.
minor daughter has been kidnapped.
There is no kidnapping from so far I am concerned.
See, there are two options now. Either you appear there and apply for regular bail. Till then we protect you, or
Yes,
we
yes,
call for
Malay,
that.
I will appear within 15 days, till days I will.
Heard Mr. Spencer, counsel for the petitioner, learned additional PP. It is submitted that the charge sheet has already been laid. Learned counsel for the petitioner submits that he shall appear before the learned court below.
Unless
But it is
CJM
be-
has no power.
It is before CJM Sessions Tribal case.
Sessions, I will- before sessions, I will.
How can you appear before
They
sessions?
are not committed unless it is.
It is not committed, lordship.
Well, I will appear the CJM, my lord, and he will committed the matter.
But you'll go behind then.
I may be,
See, better we call for the TCR.
My lord.
If we find that
Yes, my lord.
everything is in order, from here itself you can get the.
Yes, my lord, my lord. That is may be called, my lord.
Yes, sir, that is submitted that charge sheet has been laid, hence call for the scanned copy of the TCR along with the CD.
It is record come from CGM. Kolpara. Since it is not committed, so TCR is not,
That is up to registry.
my lord. In the meantime, I will protect you. Absolutely nothing against me, my lord. I am a
Not,
rich
now,
person, my
not
lord.
now.
Since it was not granted earlier and nothing
Yes,
has changed, how can we grant now?
Till the receipt of
Good,
the debt
good.
cannot be counted.
Betul, betul, ha? Mut kunjung papa.
Which receipt? No?
Puri packet. Yes, sir. Hello, hello.
Wait, please, your lordship. Here is bill application, lordship. FIR is at page 25.
Yes, that is it.
Facts of the case is, my lord, that I am the owner of a saloon, my lord. One of my employee committed suicide in my saloon. Thereafter, the family members, my lord, lodged an FIR alleging that it's a case of murder, my lord. That is the whole fact. And page 25 is the FIR, lord.
PM report is there.
PM report is yet to receive, my lord. Address case diary we have received, my lord.
What is the point of receiving the case there if we don't PM?
We can see the FIR, lord. From the FIR only, it is very clear. With due respect, I would like to inform you that an incident took place at Zone Saloon located at third floor of Shankar Apartment, Krishan Basti, Guwahati, which is owned by Mukesh Agarwala. My brother, Sakang Bania, has been working in the aforesaid salon for the last 4 years. Yesterday, on 9th October 2025, at around 1 p.m., Sakang called me and informed me that the areas of his monthly salary amounting to rupees 2 lakh was to be paid by Mukesh Agarwal, and that there has been an argument between them regarding the payment of money. I did not take the matter too seriously at the time, nor I did imagine that such a terrible incident will occur. But
What is
today,
available in the CD?
No, witnesses said, my lord, he yet to receive, my lord, he used to receive, my lord, salary, my lord, but last 3-4 months, my lord, he has not received salary. And my lord, that is why, my lord, there are some argument, my lord, and he was also contacting his owner, my lord, to clear his dues, my lord. But, my lord, there, witnesses are directly not implicated, my lord. And there is also a note of the investigating officer, my lord, that may kindly bear with, my lord. He has also verified the CCTV footage, my lord. Yeah, but-
the withholding of salary, as per my instruction, is not correct, my lord. However, even if it is correct, it
No,
will not
withheld, my
amount
lord,
to
it was
abatement
not
of
paid,
society,
my
my
lord.
lord.
There are some dues pending, my lord.
For that period, abatement of society will not come into play.
So let us not dispose of it. We can grant him interim protection for now till receipt of the post-mortem report.
That may be done.
Heard learned counsel for the petitioner, also heard learned additional PP. CD as called for has been received. However, the post-mortem report is not available. Upon perusal of the CD, there does not appear to be any direct implication of the petitioner in respect of section 103 BNS. And as per the IO, the CCTV footage also does not indicate anything as such. However, I am of the view that in order to dispose of the instant bail application, the post-mortem report would be necessary. Hence, IO is directed to submit the post-mortem report by the next date fixed. In the interim, it is provided that in the event of his arrest, the petitioner shall be released on interim pre-arrest bail of rupees 20,000 at one surety to the satisfaction of the arresting authority in connection with the aforesaid case. The petitioner shall cooperate with the investigation. List again,
512 man.
512.
I'm available.
Then IA for suspension of sentence, has been sentenced for 5 years imprisonment, my lord. The section 10 of the POCSO Act.
Your lordship, only the measure taken up after some.
Come Tuesday, my lord then.
Hmm?
Let it come Tuesday or Wednesday.
5 years imprisonment, my lord, I'm not submitting on merit, my lord, only on the point of imprisonment being a short-term imprisonment, my lord, in terms of Kiran Kumar judgment.
Sometime we don't know now, we may not be able to accommodate.
Wednesday, huh?
Okay, Tuesday,
Well, then Monday, possible Tuesday.
Monday.
Monday, my lord.
All right. Place the matter again on
Some deep problem. May I please, your lord? My lord, I have for bail, my lord. We have been convicted under section 304 part A. We have behind the bar since 7/8/2025. 3 months behind the bar. My lord, kindly for a moment. Page number, my lord, PW1, page number 14. May I read the relevant person, my lord? Page number 15, para 8, my lord. Last third sentence, my lord. Her husband sustained injuries on the right side of the hand. Close of the PW1. Mr. lost the Azahar after 3 days of the incident, so she denied that she told before the police as well as in the Azahar that the accused assaulted her husband with salute. Her husband sustained injuries on the right side of his head. Now, my lord, kindly for a moment PW4, my lord. Page number 18, my lord. 46. In cross exam, para 14, I am reading the cross examination, my lord. In his cross examination, PW4 stated that he was not present at the time of occurrence. He does not know as to who assaulted the deceased. He does not know if accused Mohim Ali was attacked by the deceased Sabed Ali with a lathi while he was going in his buffalo cart, that the lathi hit against the body of the cart and it returned back, whereby it hit Sabed Ali on his head. Deceased got hurt on the right side of the head. My lord, now PW10, Dr. M, who conducted the postmortem report, my lord, page number 26. Second paragraph, my lord. In his cross examination, PW10 stated he did not mention the age of injury in his report. Such type of injury sustained by the deceased cannot be caused by falling into hard surface due to any lathi blow, etc. He did not find any head injury on the victim on his right side, my lord. So PW1 and 4 stated that her husband, PW1, that sustained injury on his right side of his head. But the postmortem doctor denied that he did not notice any injury. Now, my lord, kindly for a moment, PW11, page number 27, IO, close of the IO, my lord. In his cross examination, PW11.
Doctor is PW?
My lord, 11, IO, page number 27, para 28.
No, who said there is no injury, doctor?
Doctor, my lord.
Doctor is PW?
PW10, my lord. In his cross examination,
No injury on?
No injury on right side of his head. He did not find any head injury on the victim on his right side. Although the PW1, the wife informant and PW4 stated that he sustained injury on the right side, but doctor denied. He did not notice any injury on right side.
PW1 and who else said that?
PW1 and 4.
2.
4. 0.
So where was the injury found? By the
My
doctor?
lord. Injury found on left side, my lord. Left side.
Yes, Mr. Burwa.
The 5 years conviction, my lord, and trial court, my lord, convicted him on the basis of materials on record, my lord. That the LCRS come, my lord, that the hearings, my
my lord,
that may be hard.
All right, we'll see then.
Kindly, we are taking bail at this stage. There is lots of lacuna in the investigation.
All right.
Highly obliged.
51, I think, adjourned. 51? Acha, or not adjourned. Somebody mentioned, oh, this was for upgradation, I think.
I tried,
Yes. Okay.
but since it would not have required. No, this petition is against order of framing of charge. Charge has been framed under section 302. Well, before that, I would like to take your lordship to the FIR, madam. FIR is at page 20. Records are there, madam.
Yes,
Petition-
FIR?
FIR at page 20.
Yes.
Petitioner, my lord, he is the owner of a pharmacy, my lord. The husband of the informant, my lord, he came to him with a problem that he had some knee pain and a injection and 2 tablets were given to him. And subsequently, my lord, and in the evening, my lord, that person expired. Well, if I may read the FIR.
Where is the charge sheet now?
Charge sheet starts from page 33, my lord. The operating part, my lord, you'll find from page 35. 35 below, second line from the witness. Page 35. Last 2 line, my lord, from the witness. From the witness mentioned above, he gathered the information that the owner of the pharmacy had not taken any government training, but could only buy and sell medicines, and accused gave the injection without taking doctor's advice. The expert opinion suggested in the FSL report shows organophosphorus insecticide positive test. Apart from the report of the FMC, postmortem was taken and Dr. So-and-so, professor of the HOD of the forensic medicine, police surgeon Borpeta pronounced the reason of the death of Babul Ramshari was due to organophosphorus insecticide. But this is an pesticide, my lord. That is the FIR was registered under 304, my lord. Thereafter, charge also filed under 304. I have annexed the 161 statements, my lord. Records are also there. None of the statements, my lord, taken under 161, my lord, indicates that there was any enmity amongst the deceased and the petitioner before your lordship. Now, my lord, and they are not known to each other also. None, even the FI does not speak of that, my lord. Speak of any enmity, my lord. 161 statements are annexed, my lord. They also do not say, my lord. If I may take your lordship to the 161 statements, my lord.
Is the PM report available in the PCA?
It's there, my lord.
My lord, audit purpose, my lord, lordship may come to page number 59, my lord. This is the order framing charge, my lord. Lordship may come to paragraph number 4, my lord.
Yes.
May I read, my lord? The IO of the case submitted search sheet against the accused under section 304 of the IPC. Final opinion of the doctor is that the deceased died due to organophosphorus insecticide poison.
No, my lord, what is the
As-
organophosphorus?
As far as I know, organophosphorus insecticide is not in liquid form.
Yes.
It is in solid form, in
My
powder.
lord,
But
chemical, my lord.
whether it can be injected,
That is the report of the, my lord, doctor, on what basis, my lord, the learned trial court, my lord, the frame charge, my lord. Now, my lord, if lordship may come to paragraph number 4 of the, my lord, paragraph number 5 of the application, my lord. Paragraph number 5, page number 4, my lord. He is the, my lord, owner of the pharmacy, my lord.
Hmm.
Whether, my lord, he is authorized to, my lord, prescribe this injection, my lord, to the accused person, my lord.
Yes, my lord.
Sorry, to the victim, my lord.
Another proceeding is pending against him, my lord. My lord will find at page 60.
No, now, my lord,
Page
we are
60,
concerned about the, my lord, framing of search, my lord. Whether there is any irregularity in framing, my lord, that has to be considered, my lord. Because trial court has same search, my lord, on the basis of materials collected by the IO, my lord. On what basis, my lord, the search has been submitted, and now the search has been framed, my lord.
No.
So it is a matter of trial, my lord, at this stage.
My lord is aware, my lord, for 302, without eyewitness, intention or motive is paramount, my lord. Here, the deceased and the petitioner are not known to each other. Neither the FIR nor the 161 statements, my lord, reveals that there are or is any enmity, my lord, amongst them, my lord. So a person not knowing the other person, my lord, why would there be any intention? Rather, would there be a criminal intention, my lord, to kill that person? At best, my lord, in my humble submission, my lord, it would be a case under 304A.
according to you, what was the injection given?
My lord, INEC.
Hmm?
INEC. I've stated in my petition, my lord, INEC and tablets were zeroed off.
So to quasi, my lord, judicial order, my lord.
302 not accepted in my humble submission. Charge sheet as well as the FIR were registered and are under 304.
Page, which was the charge order? Page?
Charge 59, my lord. Records are there if, my lord, once I can go through the 161 statements. I annexed also, my lord, the translated ones are there in the record.
Yes, what about 161 statement?
Yes, my lord. It starts from page 44, my lord.
That he had no enmity.
No, no enmity.
That is what we want to point out.
Yes, yes, yes. They are not even known to each other, man. Offense is there, Malu, without doctor's advice, the injection was
So
administered.
you say some separate proceeding is going on against him
Yes, ma'am.
for that purpose.
Yes,
Is that
yes, page 60, Malu.
right?
Page 60 under the Drugs and Cosmetics Act, Malu. You have appeared, Malu, the trial is going on, ma'am.
All right, CIV.
My lord, another aspect of the matter, my lord, Lordship may kindly come to page number 36 one, my lord. This is the relevant portion of the search sheet, my lord.
36.
Page number 36, my lord.
Yes.
During investigation, investigated the place of occurrence, sketch map was drawn, informant and the witnesses are being inquired. These documents and postmortem report and also along with the FSL report, it is found that the accused Juran Ali Ahmed on 24/6/2024, Babul Ramsari was suffering from severe pain. For that, he had gone to the Asiful pharmacy located near Majorgaon, Sariali. During the investigation, it is found that the owner of the pharmacy, that is the accused of the instant case, named Juran Ali Ahmed, without the advice of the doctor, he gave an injection to Babul Ramsari and prescribed 2 tablets. Though the accused Juran Ali Ahmed is the owner of the pharmacy, but he could not produce the documents showing that he can give injection or he had the right to prescribe medicine himself.
Now, in that respect, that other proceeding is going on.
Yeah, other proceeding, but at
Please,
least
Madam,
as my lord.
302.
Whether my lord, if lordship is interfere with this order framing search, my lord, there has to be some materials, my lord, that trial court has not considered, my lord. Only then, my lord, this order can be interfered with, my lord. Because on the basis of materials available on the record and after, my lord, going to the my lord, search sheet, my lord, the trial court has, after hearing the parties, my lord, and the trial court has passed this order, my lord, which has
We
been
have to
challenged.
see whether the trial court has applied its mind to the material available on record. What is the link? What is the connection between the injection? and the-
Connection is that, my lord, he gave the injection, my lord.
Yes, he gave the injection. He may have taken it also, ingested
Yes.
it also. Who knows?
Because, my lord,
That is, there
injection-
should be some material there.
The question is that, my lord,
Injection was
prescribing a, my lord,
administered, my lord.
prescribing a
was
medicine and
administered
giving an
in
injection is
part, my
different, my lord.
Injection was administered in the morning before 10 o'clock and the person expired in the evening.
Yes, my lord.
Now, within
the
this
very-
period.
on the same day,
and
my lord.
Within this period, my lord, that insecticide, organophosphorus insecticide could have been consumed also. There are two various views possible, my lord.
Have you seized the syringe?
That is not there.
How will you link it?
That's not
That
there.
it was that organophosphorus that was found in his
That is the report.
viscera originated from the injection given by him.
These are a matter of
How
trial,
will you
my lord.
originate that?
Trial, these are a matter of trial, my lord.
No, when there is no material available at all, on the basis of what will that be proved?
No,
If you had these,
witnesses have said, my lord.
no, witnesses only said he gave an injection. They did not say they gave him
Question is, my
organophosphorus
lord, whether he is
injection.
authorized to give this injection,
No,
my
that
lord.
is a separate proceeding.
That is not.
Separate proceeding is going on. Under that, no charge has been framed. Here. So let us see. We'll have to do some research, I think.
For 302, my lord, intention is paramount, my lord. Had there been some fight between two parties and there are eyewitnesses, then motion is
had-
not required.
No,
Now-
had it been poisoned, then intention would have been apparent.
Yes.
No other intention is required to be proved. Suppose he had injected poison, what other intention is required to be proved?
Whether there is any,
Whether the medicine, my lord,
Materials,
the
whether-
medicine which is he has, my lord, injected, my lord, the injection, my lord. Whether it was, my lord, the proper at that point of time to inject to the victim, my lord, that has to be looked into, my lord.
No, we are only
Because he
concerned
cannot-
because
he
the
cannot give
cause
a
of death is
painkiller.
organophosphorus. So we are only concerned with whether it was
How
injected.
this poison occurred then, my
Some
lord.
other injection is not relevant if.
Let the trial proceed, my lord.
Yes, CAB we have said. Let's go to the next case.
One thing I would like to point out, the service upon the respondent number 2 informant is not yet complete.
Oh, then
And I'm
After
Pray
hearing,
and-
my lord, now is submitting this.
now, that is why it is listed for others. My friends should know that why it is listed for others.
then that is the first thing you should say.
Now, my lord,
Let him appear, my lord.
I appeared, my lord. I appeared. When I am on bail now, my lord. Next date is fixed on 13/11, my lord.
No,
for
no, I'm not
evidence.
talking about your appearance, the informant's appearance.
I'm only praying for a stay, my lord, now. Let the informant appear, let him submit, my lord. Then my lord will take a decision. Well, now, apparently, my lord, charge under 302 is not called for, my lord.
All right, we'll,
Now,
we'll
my lord
keep it
will decide from the materials available whether 30.
No, CAB will pass order, some order. Yes, next case.
Deeply obliged.
Chamber.
In my please, Your Lordship. In item 60
Yes,
67, notice has not yet been served. I have seen the office note 4/11/2024.
as per office note, service on respondent number 2 not yet complete. Await interim order passed earlier to continue. List again on.
All right.
The mic is.
This is what, passed over earlier.
Yes, madam. Your Lordship, suggested it should come up on 10th,
Ah.
but my learned friend had
Oh,
already
cha,
appeared.
already appeared.
In this case, my lord, I was convicted under section 10 of the POCSO Act, and my lord, imprisonment was of 5 years, my lord. So at this stage, my lord, since the IA has come up, my lord, I'm only submitting on the point of sentence, my lord. Since a short-term sentence has been given, my lord. So in terms of the Kiran Kumar judgment, my lord, I'm submitting that the sentence may be suspended. Otherwise, on merit also, my lord, there are issues because there are 2 victims. As far as the first victim is concerned, there is a delay of 3 years in her lodging the FIR. And the allegation was that the applicant before your lordship had molested his students, my lord, while he was giving tuition, my lord. Now, 5 witnesses from that same tuition group had deposed evidence, and they very categorically stated that all these tuitions were taken in a group and not alone, my lord. So that part was, my lord, not considered. Can you, my lord, that is something your lordship will consider during the final hearing? At this stage, my lord, only on the length of sentence, my lord, I'm saying that sentence may be.
Yes.
Lordship is aware, but I'm submitting Kiran Kumar judgment.
I think we had passed orders in a similar matters earlier.
Yes, my lord. That was 6 years, my lord. Last week, your lordship granted it on bail in a 6 years case. This is 5 years. And I'm already in custody for, my lord, more than 10 months, my lord. 307.
Big one.
W2.
You have the date and case number of that order.
My lord, I can give it, my lord.
Yes.
Victim examined as PW two, my lord, and person may come to page number 28 of the, my lord, memo of appeal, my lord. IA, my lord, IA. page number 28, my lord, of the interlocutory application. And trial court findings, my lord, paragraph number 39, page 54, my lord. Trial court findings. Paragraph number 39 of the judgment, my lord, and my lord, page number 54 of the interlocutory application.
All right.
Lordship, under the POXO Act, Lordship, allegations are there. The case is that accused has,
Not
Lordship,
allegation, conviction.
Lordship, that, Lordship, there are two victims, Lordship. Victim X as well as Y, Lordship. Both the victims were tutored by the convicted person, Lordship. So they
We'll
use,
go through.
Lordship.
Just my lord, just pointing out in clarification, I submitted my lord. PW2 and PW3 are the two victims. They have, first PW3 was the student. 3 years later, PW2 was being the sister also went to the same tuition. So PW3, first she says that for 3 years she was molested, she does not complain. And then when her sister goes, take tuitions there also, she does not object. Only when the sister makes this allegation, then the PW3 also comes and says that 3 years ago he had also molested me. So there is a delay of 3 years in that respect. Another aspect, my lord, which your lordship will also consider that DW1 to DW5, all are the students of the same tuition group, my lord. And they had very clearly stated that these tuitions were always taken in a group, not alone, my lord. So those are aspects, my lord, anyway, your lordship will examine during hearing, my lord. The judgment, my lordship had given, my lord, IA criminal, my lord, 437 of 2025. IA criminal 437 of 25, order dated 28/10/2025. Same principles will also be applicable in my respect.
Order dated
28/10/2025, ma'am. I'm deeply obliged, ma'am.
Obliged.
as he ordered. I think nobody is appearing in this matter on the last dates also, so. Matter of 2014. Yes, what is to be done here? Nobody is appearing and I think it's notice may be issued. I think. Yes.
If there is some interim order.
No,
then
we can appoint amicus curiae, but I am not sure whether he is still alive or not. That is why notice to the petitioners maybe.
If there is interim order, then maybe vacated well.
This is regarding maintenance from the year 2014.
Let them appear then well. Between the two private parties.
Let them.
Let them appear, my lord.
Appear means here. No, we are required to dispose of this, but
Or notice may be sent, my lord, with all respect to the petitioner,
That
because
is
there is no
when,
fault on the part of the client, my lord.
yes, he may be unaware.
If it's vacated, client will suffer, my lord.
If none appears for the petitioner. It appears that on the previous date also none had appeared. This is a matter of the year 2014. Issue notice to the issue court notice to the petitioner. Registry to do the needful. List again on 4 weeks.
Ten years by the saw takes already over about 4 years already, almost fine. Few days back now. So I think that's because hearing matter IA is pending. So my prayer would be subject to what your worship say, my lord, IA may be considered, my lord, because hearing it may take some time, may not be possible today. So my hearing is considered.
Matter is of 21.
21.
Why can we not have it for final hearing then?
Yes,
No,
Lordship.
no, I
That
come
would be
hearing, but
better, Lordship.
normally this time.
In case the appeal cannot be heard on the said date due to paucity of time, the IA will be considered.
Obliged.
Obliged.
And in this case, my lord, I'd like to point out, it's a quashing matter, my lord, we need some time, my lord. So, in some other date, my lord, taken that.
Alright. When?
12 or 14, my lord, will do it. Bharoba should do it.
November.
Next week. I'm ready.
On the prayer of learned senior counsel. Place the matter
On 14, my lord.
14.
Okay.
But Friday, last item. Friday or Tuesday number. 12.
12 to Wednesday.
Second hour.
13 quick.
13 all बाहेरच जमलं. 14 okay, we'll try, my lord. Interim may kindly continue, my lord.
Interim order passed earlier to continue.
Much okay. Very nice.
Adjournment request. When was this? Today is what? This is our earlier.
This is for the
Last
earlier,
month.
but In fact, also inadvertently, my name has been shown as at the last request I have taken. Lordship, in fact, it was on the other side. Name has been reflected, my name.
No, anyway, this is of previous.
The matter relates to the matter, it's a matter of a company act. If the cognizance was taken inadvertently under the IPC, Lordship may have the impugn order, that is page 99 and 100, Lordship. Lordship, here we have challenged the entire proceedings that the special judge could not have taken the cognizance because there is a provision under the Companies Act. It states that it has to be taken under page 99. Annexure 2, Lordship. If I may read, Lordship.
Yes.
Lordship, page 99, Lordship. Order dated 19/1/2020.
Yes.
Complainant is present along with one witness and his statements under 200 CRPC is recorded. On perusal of the case record along with the documents and the complaint petition and after hearing learned advocate for the complainant, a prima facie case, Lordship, this is important, under section 447, 448 IPC is made out against the accused Binod Kumar Sultana. Lordship, I appear for the accused. Lordship, we'll see the complaint petition now, Lordship. The complaint petition makes a mention of the provision under 447, 448 of the Companies Act, Lordship, 2013. So, Lordship, the cognizance itself here, Lordship, that is, there is an apparent error, Lordship. Second and most importantly, Lordship, provision 212, if I may call upon my lords to have Companies Act for the time being, Lordship, I'll be able to show the provisions.
212 of Companies Act.
Companies Act, Lordship.
Companies Act.
क्या है?
Okay, you start reading.
Lordship, if I may invite my lords to have the affidavit in opposition, the judgment which they have relied and it is annexed as one of the annexures. Lordship, 212 is mentioned there also, Lord. It starts from 448, Lordship. 212 is mentioned there, Lord.
400?
448, Lordship. It starts annexure A.
448.
448, Lordships. Their affidavit in opposition. Lordship may have page 451.
What is 448?
443, it is the judgment, Lordship, on the basis of which an interim order was passed by the humble court that the proceeding should be stayed in the lower court. It was on the basis of this, Lordship. And this Lordship judgment definitely covers my case. 451, Lordship, page number.
451.
451, Lordship. Here the section 212 is mentioned, Lordship. This is part of the judgment, Lordship. Lordship has found at 212, Lordship. 212.
This page is what you're referring.
Lordship, page 51, Lordship.
Okay, let's go to the act.
Yes. $212, Lordship.
Yes.
Investigation into affairs of company by Serious Fraud Investigation Office. Number 1, without prejudice to the provisions of section 210, when the central government is of the opinion that it is necessary to investigate into the affairs of a company by the Serious Fraud Investigation Office. Number 8, a receipt of a report of the registrar or inspector under section 208. Number B, on intimation of a special resolution passed by a company that its affairs are required to be investigated. Number C, in the public interest. Or number D, on request from a department of the central government or a state government, the central government may, by order, assign the investigation into the affairs of the state company to the Serious Fraud Investigation Office, and its director may designate such person of inspector as he may consider necessary for the purpose of such investigation. Number 2, where any case has been assigned by the central government to the Serious Fraud Investigation Office for investigation under this act, No other investigation agency of central government or any state shall proceed with investigation in such case in respect of any offence under this act. And in case any investigation has already been initiated, it shall not be proceeded further with, and the concerned agency shall transfer the relevant documents and records in respect of such offences under this act to Serious Fraud Investigation Office. Number 3, where the investigation into the affairs of a company has been assigned by the central government to a Serious Fraud Investigation Office, it shall conduct the investigation in the manner and follow the procedure provided in this chapter and submit its report to the central government within such period as may be specified in the order. Number 4, the Director Serious Fraud Investigation Office shall cause the affairs of the company to be investigated by an investigating officer who shall have the power of the inspector under section 217. The company and its officer and employees who are or have been in employment of the company shall be responsible to provide all information, explanation, documents, and assistance to the investigation officer as he may require for conduct of the investigation. 6 is important, Lordship. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the offence is covered under subsection 5 and 6 of section 7, section 34, section 36, subsection 1 of the section 38, subsections 5 of section 46, subsection 7 of 56, subsection 10 of section 66, subsection 5 of section 104, subsection 4, section 206, section 213, section 229, subsection 1 of section 251, subsection 3 of section 339. Now these are important, has been incorporated, and section 448, which attracts the punishment of fraud provided in section 447 of this act, shall be cognizable, and no person accused of any offence under those sections shall be released on bail or on his own bond unless the public prosecutor has given an opportunity to oppose the application for such release. Number 2, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and he is not likely to commit any offence while on bail, provided that.
Which subsection is this?
Lordship, these are all subsections of Companies Act.
No, you are reading which one?
Number 6, Lordship.
Before,
notwithstanding-
no, before that, what were you reading?
212, Lordship, subsection 6.
You started with subsection 6.
Subsection 6. It makes a mention, Lordship will see section 448, which attract the punishment for fraud, which is the present subject matter before my lord. 447 and 448 are the subject matter. If I may read it again, my lord.
Subsection 6.
Lordship.
Yes, notwithstanding anything contained.
Lordship.
Public prosecutor notice
Public. Then my lord will see. The
opposes the
proviso.
application so and so.
Then my lord the proviso.
Yes. Special.
Provided that a person who is under the age of 16
Okay.
or is a woman or say a release on bail if the
Then
now,
further the
Lordship, this is
special
important.
court not take cognizance.
Lordship, this is
Yes.
provided further that the special court shall not take cognizance of any offence referred to under to this subsection except upon a complaint in writing made by number 1, the director, SFIU. Number 2, any officer of the central government authorized by a general or special order in writing in its behalf on the Lordship. The withstanding section includes 447, 448, and this proviso makes it explicitly clear that without the SFIU and the central government, nobody can take cognizance of any offence under section.
Only 447 is mentioned. Where is 448?
Just above that, and section 448, which attracts the punishment of fraud provided in section 447 of this act, shall be cognizant. 447 is the punishment, my lord. I'll take my lord to 447, 440.
Not doing anything only as is covered under section 96 will be cognizable. Those sections. Let us see 447 and
Yes, my lord.
448.
447. Punishment for fraud, 447.
447 is punishment for
Punishment
fraud,
for fraud, Lordship. If I may
and
read
448 is punishment for false statement.
for false statement, Lordship.
So there are separate offenses.
These are two separate offences. Now my Lordship will see.
No, in subsection 6,
Lordships.
we only find mention of 447.
Lordship, it's 448, the punishment of which is 447. Lordship will have 212 for a moment.
Okay.
After section 339, it is mentioned section 448.
Where in section 6?
Yes, Lordship. At section 6, after section 339 and section 448,
I think we are reading different books.
Lord, I'll just indicate. I have a mark on it. I'll just, so it will be easier for my lords. I've underlined it, my lord. If section 6, I have underlined 447 and 448.
No, I think this has been amended. These are two different provisions from this book, and yours is 2014, mine is 2024.
So then other point of Lordship, I'll just indicate.
In that case, my lord, this matter may kindly be listed on next Tuesday, my hearing day. So that I may also go through, because I have also the old one. Okay.
That is why I was not getting what you were saying all the time, because
I'm also 2015. Let me have a fresh book, my lord.
normally we are supposed to have the old books, you are supposed to have the new ones.
Exactly. I apologize for this.
If possible, my lord, on next Tuesday,
All right.
hearing day. And let it be kept as the part of my lord.
We have hardly heard. On the prayer of learned council for the parties, list the matter on Tuesday. Give the date.
See, may it be on Thursday, Lordship. Today I have some
Let
difficulty,
it-
Lordship. May
All
it be
right.
on Thursday, Lordship. Subject to my lord's convenience. Thank you.
Much only.
Deeply obliged.
Keep this together.
I did one.
Right, please, Your Lordship. This is a regular bail application, Lordship. In connection with Bhangar PS 148, same matter, Lordship, today's, I don't know, 5, Lordship, PA number, Lordship, 3582, Lordship, maybe.
What order was passed there?
Lordship,
What order was passed in item 5?
Lordship, call for CD, Lordship, maybe fixed one, 1211, Lordship.
All right. Call for the CD list again on 12, 11, along with the other one. Along with the item number 5.
PA number 3582.
Yes.
Oblige, Your Lordship.
Lordship, yesterday already anticipated a bill also listed by lords. That already today order we upload. So my lord, there is a wrongly Navir Hussain instead of Fulbhanu, my lord.
I'm not
Right.
following a single word. What are you submitting?
My lord, anticipated bill, my lord. So correction, my lord.
Correction.
Yes, my lord.
You have filed any application again for correction? You have to file a application for correction, modification of the order of only correction.
Today online.
Files online. So-
If there is any mistake in the order, you
Or
file a
you
proper
proper
application
application.
seeking the correction.